Okay. Good morning. In accordance with sections 45 and 53 of the Planning Act 1990 as amended, this meeting for the Committee of Adjustment for the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning bylaw that apply to the property, permission to extend or alter lawful nonconforming uses, and consent to sever property to create new lots. My name is Nancy Oman, and I will be chairing this hearing. Panel members participating via WebEx webinar and in person who can be seen and heard are Larry Clay, Carl Nipfel, and Aaron Cheng. We acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and it is now home to many diverse First Nations, Inuit, and Métis peoples. We acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Committee of Adjustment public hearings are now conducted in a hybrid in-person and virtual format. Some submissions will be presented in person and others by electronic means through WebEx, an online digital platform. You can also watch our meeting live on the Toronto City Planning YouTube channel. Participants who want to participate virtually registered in advance and will be connecting to the hearing using a phone or compatible electronic device and are able to participate via video or audio. Participants will be muted automatically upon entry. When your item is called, participants will be unmuted one person at a time by the moderator. Please mute your devices until called upon to speak. Those participating by video will be temporarily upgraded to panelist when their item is called, and during this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time, and at all other times your video will be disabled, and you will be reinstated as an attendee. Committee of Adjustment staff will assist us by sharing presentation material received within the written submission deadline. Members of the public and applicants are not allowed to use the share screen or any other panelist controls during a video appearance. The host will remove you from the panelist role if you fail to respect the instruction. Those attending in person who wish to receive a copy of the committee's decision on an application must fill out the decision request card, and anyone attending virtually must submit a written request by email to the general email address for the Committee of Adjustment, Toronto and East York District Office. Please include your name, address, and an email address. Committee of Adjustment and TLAB notifications and appeal updates will send by email only. If you do not agree with the decision of the committee, decisions may be appealed to the Toronto local appeal body known as TLAB, or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government recently amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. As of November 28, 2022, only the applicant, the Minister of Municipal Affairs and Housing, specified persons, and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. Where an application is uncontested, the agent or applicant may proceed with their presentation if desired. And when the committee does not require a presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and/or take the matter into committee for a decision. Each speaker, including the applicant or agent, will be given a maximum of 5 minutes to address the committee, and I will comment when you are reaching the 5-minute mark. When addressing the committee, please speak slowly and clearly state your name and address, and please confine your remarks to the matters outlined in the application. The applicant or agent will proceed first with a presentation of the application, and then individuals either in support or opposed to the application will be invited to speak. Committee members may ask questions of each speaker after they have completed their presentation. When all speakers are finished, the applicant or agent will be unmuted and will have an opportunity to rebut only those issues that were raised by the speakers. And this will mark the end of the discussion, and the application will be taken into the committee for a decision. When a presentation is not required, panel members may ask questions and/or take the matter into committee for a decision. Please note, the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if substantially revised to ensure the revised application is accurate and that all those entitled to notice are informed of the changes. Madam Deputy Secretary Treasurer, are there any minutes to be confirmed?
Good morning, Madam Chair and panel members. There are no minutes ready to be confirmed for adoption today.
Okay. Are there any declarations of interest by staff or panel members? Mr. Cheng.
Yes. Good morning.
Good morning.
It is case number 17. I wouldn't be able to join.
Okay.
504.
Number 17?
Yes, correct. 504 Beresford.
Okay. And the reason for your conflict?
Is because I have received a letter of hearing. So I'm living in in the area in one of the I'm living one of the houses in that area.
Okay. Thanks a lot. Any other declarations of interest, panel members? No? Are there any files to be closed?
Through you, Madam Chair, there are no files to be closed today.
And I believe there is a deferral request.
Through you, Madam Chair, yes, I see one request for deferral. That is for item number 15, municipal address, 297 Delaware Avenue, file number A0664/23TEY.
Staff, do we have anybody virtually waiting for this one?
I believe we have one member in person
Okay.
speak to this item.
Did we have any others registered to speak? Let me just see. 15.
There is another member person registered to speak in opposition.
Okay.
Staff, do we have them online?
No?
That is for item 15.
15. Okay, so I'm going to just go in order then if we don't have the person online yet. Okay, thanks. The first item is item number 1, 13 Mansfield Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, 3 photographs of the subject property, decision number, previous committee decision that affects the property, a revised site plan, supporting materials from the agent that was received in our supplemental agenda. We have email correspondence from transportation, and let me just go to my notes here. They don't have any concern as long as the 1.56 meter from the center line is maintained. We have 2 form letters in support from owners at 15, which is adjacent, and 239 Bellwood. We have a staff report from community planning asking for a condition. That also came in the supplemental report. And we have opposition from number 11, the other adjacent neighbor, and 266 Claremont Street. I'm not showing any opposition speakers online. Is there anybody here in person that wants to speak to that item? No? Okay. Is the agent present in person or virtually?
I'm here, I'm present.
Hi, can you just state your name for the record?
My name is Simon West.
Okay.
Address.
Panel members, do we need a presentation on this? Or Mr. Nipfel has some questions for you. We don't need a presentation, thanks.
Can I go ahead?
Yeah, go ahead.
You submitted a revised site plan, and my understanding was that the difference was that the platform and the stairs that are leading into the suite from the laneway were being removed and replaced with soft landscaping, but at least on the drawings that I saw last evening, that didn't seem to be the change. So maybe the revised site plan can go up on the screen, and can you explain what you've changed? Because you had to,
Yes.
you gained more landscaping at the advice of planning, right?
That is correct. So what I've done is I've removed the rear walkout from the basement, and that's not located in the laneway portion of the house. It's located in the of the property between the laneway and the actual existing residence, therefore giving more than 60% of soft landscaping that's required. And you can see the area is bubbled.
Yep.
It's ground floor walkout removed.
Okay, no, I can see there was a stairway there before. Okay, thank you.
Yes.
Just, sorry, I should have asked you this before. So does this mean that you are removing variance number 1?
That is correct. We've met variance number 1. It's no longer a variance requirement.
Okay, so we're looking at the amended application then with variance 1 deleted.
Yes, and planning sent you a letter regarding that removal.
Yeah, I did see that, but because the notice went out as such, we do need you to formally remove it at the meeting.
Okay, so item number 1 has been formally removed.
Okay, thanks. And Mr. Clay has a question.
Thanks, Chair. Simon, I recall this one when it was before us before. The concern of the committee at that time was really about the separation distance between the main dwelling and the proposed suite. Has that changed at all, or have you kind of just made the other changes?
No, actually, the concern was actually the height of the building. So in the initial design, the building was 6 meters tall. The setback has not changed because we're using the existing garage.
Right.
So the height of the building has changed from 6 meters to 4.32 meters.
Okay.
Okay, any other questions, panel members? Okay, sir, Mr. West, is there anything you want to add before we take this into committee? And as a side note, I assume you've read the comments made by the adjacent neighbor. I know they're not under our jurisdiction, but will you be having discussions with them?
I've tried phoning the lady. The daughter's name is Paula, and I've left 3 messages with her phone number. She doesn't actually live at the house. Her mother lives at the house. Her mother's name is Ilda. We have spoken to her, and she gave us Paula's phone number. I phoned, and I'm getting no reply from her. So I don't have any issues with any of her comments, because, as you say, they have nothing to do with Committee of Adjustments. They're more about property rights than anything else.
Yeah. Okay, well, I guess all I can say is keep trying, and hopefully things will get worked out between the neighbors. So is there anything you want to add about the application itself before we go into committee to make a decision on this?
Yes, if you don't mind. So the original intent of this project is to build a laneway suite within the existing garage footprint. The existing garage is 4.25 meters tall. The proposed new laneway suite will be 4.32 meters tall. The intention was for it to be built and designed as a 1-story unit, but due to definition of average grade to where you measure floor heights, the building actually became defined as a two-story building, whereas in reality, if you see other supplementary documentation, you'll see that this building actually appears to be a 1-story building. The intention was never to have this redesigned as a 2-story building. So it was intended to be a 1-story building with a 5-meter setback, but the existing building is 4 meters. So we're asking for the variance of the setback as well as the height. But the intention was for this building to be a 1-story building. But by definition, unfortunately, it's become categorized as a 2-story, even though when you look at it from an elevation point of view, it still appears to be a 1-story building.
Okay, thank you. And you are maintaining the 1.56 meters from the center line, correct?
That's correct. Actually, it's 1.55 meters, not 1.56.
Okay, I thought I misread what transportation. I thought they said 1.56, but their
They said
email does.
1.56.
Yeah, their email does say 1.56, but close
Sure,
enough.
Yeah, but it's actually 1.55.
Okay.
Just a quick question, if I might. Simon, there's a large structure behind the lane, behind where your client's property is. Is that a residence?
think it's a mixed-use building. I think there is residence in there. I also think it might be used for some commercial storage facilities. Not much happens with it. I think it's mostly residential, and then some of it has to do with storage, but I have been told unofficially that it's more residential.
Yeah, it's just an unusual configuration in behind a laneway.
Yeah, I agree.
Okay.
Okay, if there are no further questions, we'll take it into committee for a decision. Panel members, Mr. Nipfel.
Thank you, Madam Chairman. I think this is a very reasonable application. I appreciate the negotiation that took place between the planning department and the applicant, and it appears that that's improved the application somewhat, not ideally, but somewhat. So I would like to move approval of the amended application with, I think it's variance number 1 deleted. I don't believe we need to add the planning department condition, but I do think if we, in order to cover it, we should tie any approval to plans. And there is a transportation condition about the setback, as you already noted, Madam Chairman. I don't know if we need to call that out or whether, in fact, the revised plans show that sufficiently.
I would say note, we can note it. I mean, there's a 0.01 difference apparently.
Okay, so perhaps with the transportation condition as well?
Okay. And that's seconded by Mr. Clay. So we approve the application as amended with the deletion of variance number 1, transportation condition to maintain the 1.56 meters from the center line and tying to plans. All in favor? That carries unanimously. Thank you. Item number 2, 45 Dunvegan Road. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, 4 photographs of trees on the property, supporting materials by Mr. Romano, the agent. We have email correspondence from transportation in the supplemental agenda. They don't have any concerns. Forestry is asking for condition number 1. Correspondence in opposition from number 43 and 47, both adjacent neighbors, as well as 48 Forest Hill, and a 5-signature petition in opposition from residents at 30, 34, 35, and 43 Dunvegan and 42 Forest Hill Road. I'm showing 1 opposition speaker. Is that person online or there? Okay. All right. So, and is the agent online?
Morning, Madam Chair. Franco Romano, 321 Lakeshore Road, Fort Credit.
Good morning, Franco. Can you please do a presentation, no more than 5 minutes? We'll start the clock now.
Yes, kindly. Thank you, staff. You beat me to it. This is an application that's proposes, actually, if we go to slide 1, that'd be great. Correct, yes, perfect. This is an application that proposes to construct a new detached dwelling. It is 3 stories in height, and you'll see in the front elevation that the 3rd floor is built fully within the roof line. The proposal is for a property that currently has a building that's located deep into the lot, and it's on one of the smaller lots in the neighborhood and on the street. It's a 9.6 meter lot frontage, and it has a context where the other properties along Dunvegan Road, except for the neighbor to the north, is they're all larger properties, closer to the minimum required 18 meter lot frontage. That 18 meter lot frontage is what triggers the 1.8 meter side yard setback requirement. If you will recall, many of you have been on the panel or practice in this part of the city, that the former Toronto zoning bylaw would have allowed side yard setbacks up to or down to 0.45 meters in much of the neighborhood. So what we do see within this neighborhood are properties that are tight to wide side yard setbacks, building lengths that are in excess of the zoning bylaw. And what is being proposed here is something that is in keeping with that overall character. The front yard landscaping is being improved. You see the driveway swings in order to protect trees. The building length is articulated. The building length for the living portion of the building is for the first and second floor about 20.8 meters. The zoning bylaw interpretation is measuring some of the length and depth to include the covered patio, the walkout, as well as the bay window, and underground it's for the front below grade parking space that's going to be located in front of the dwelling, underground, accessed by elevator, and it's underneath the driveway only. That's the only portion that has that extra building length. The third floor is built fully within the roof, and we'll see that there's a dormer in the front, and then there's screening from the roof to the balcony in the rear, which is not at variance. And what we see without the third floor area is that the proposal would have a floor space index of 0.61, and the front yard setback is actually moving the building forward to be more in line with what's found on the street. And if we can go to slide number 2, please. We'll see that slide number 2 shows that buildings are generally within the 7 to 10 meter front yard setback line, and building lengths and floor space indices in excess of 0.35 and in excess of 17 meters and 19 meters in building depth are quite common. And just to put it in context, the neighboring dwellings to this subject property currently have gross floor area of just over 400 square meters and just over 460 square meters. And the proposal is at 410.7 square meters. So the proposed gross floor area and floor space index is in keeping with what's occurring on the street, and there's no unacceptable adverse impact. Subject to any questions, Madam Chair, we have worked with this city staff and are in agreement with the conditions of approval from Urban Forestry. Thank you.
Okay, thank you. Carl, did you have a question, or we'll hold questions? Or
Just one
Yeah,
question,
go ahead.
because I think it's relevant to whatever anybody wishes to say. Mr. Romano, one of the prevailing themes of the opposition is that there's been no pre-consultation, that they weren't consulted at all about this proposal. Could you speak to that?
Certainly, I have talked to, and thank you for that question through you, Madam Chair. The owner has reached out to neighbors, had extensive discussions with persons that were available to discuss, including number 47. We were quite shocked to see that letter that was written and submitted yesterday. It seems to have been written based on some influence that others have provided to them. You'll see in that letter that there's a discussion about things that have nothing to do with number 47. But number 43, I know that my client has approached our property and knocked on that door well over a handful of times, and there was received no response. So it's difficult to speak to individuals when they're not accessible, and but the owner has reached out to people and has had discussions with those persons that have made themselves available to do so, and will continue to do so, I might add.
Thank you.
Okay, thank you. We'll hold further questions till after we hear from the opposition. So if you could come to the front and introduce yourself, please. Okay, after you've introduced yourself, we'll start the clock. You have 5 minutes.
Good morning, Madam Chair and committee. My name is Andy Margaritis, and I am legal counsel to Mr. Sheldon Switzer, the neighbor at 43 Dunvegan Road, immediately abutting to the south of the subject property. My client has lived at this home for about 35 years. We are asking the committee to refuse the variances today, and although not a legal requirement, I can confirm as of this morning there has been no attempts that we are aware of for any sort of communication or discussion about this application, either prior to or after the committee's notice was mailed out. We did file written submissions on September 6th, and I'd ask Mr. Nadeau to have those available so that I may refer to them in particular, starting on page 8 of that material. In terms of maintaining the general intent of the official plan, a defining characteristic of the Casa Loma neighborhood is the expansive and vegetated spaces between homes, which are described in this attachment. There's maybe 30 photos or so. And these are photos all taken for homes on both sides of Dunvegan and Forest Hill Road between St. Clair and Lonsdale. The reduced setbacks proposed, particularly the side yard setbacks, will result in a built form condition that will not respect the existing physical character of the neighborhood, will not maintain the prevailing pattern of expansive side yard setbacks and open space between homes, and will not maintain the general intent of the official plan. With this neighborhood character in mind, I'd like to now discuss how the 7 variances will directly impact my client. Starting with the side yard setback and referring to page 3, Mr. Nadeau, the proposal seeks to completely undermine the expansive side yard open space characteristic by proposing a 47 centimeter side yard setback adjacent to my client's home. As can be seen, the existing condition is up there. The applicant wishes to reduce this existing condition by nearly half of what exists today. This area between homes is the only direct means of access my client has from the front to rear of the home. If approved, this application will result in a long, dark, narrow, bowling alley type corridor. Turning to the front yard setback, and Mr. Nadeau, if you can refer to page 4, a key architectural feature of my client's home is the windows contained within its main stairwell. And you can see those in this photograph to the right-hand side. There's a bay window, another window on top, which are in the stairwell, and 2 windows on either side of that upper window that are bedrooms. The bank of windows allows light to access the stairwell and into the home's hallways, which can be seen on page 5, Mr. Nadeau. And when you look here, you can see the current location of the 45 Dunvegan front wall, which allows light into my client's stairwell and windows. The proposal seeks to reduce the front yard setback by 1.6 meters, which will result in the front wall of the home being closer to the street and in turn completely covering those windows. The combination of reduced front yard setback and side yard setback will result in the complete loss of light to these windows, which could have been avoided through thoughtful design and discussion. Turning to the length and depth, and to summarize thus far, the applicant wants to build a home closer to the street than permitted and closer to the side yard than permitted. It also seeks rather significant increases to the permitted length and depth, which will result in a built form with a dwelling length of over 22 meters above ground and a dwelling depth of over 20 meters above ground. Leaving aside the quantum of length and depth variances, which in my view are objectively not minor for this undersized lot acknowledged by the agent, one must consider these variances cumulatively in the context of the setback reductions requested. All of a sudden, the proposal is seeking a sidewall condition, and you can see this on the south elevation of the architectural drawings, that but for one window is a blank wall, is greater than 22 meters in length, and is located 47 centimeters from the shared property line. This is hugely impactful. And focusing now for a moment on FSI, they're seeking 0.8, which is more than double what's permitted. We've done the research on Dunvegan, Warren, and Forest Hill on this section, and the prevailing FSI is about 0.7 for lots much larger than this. And as a result, in my respectful submission, we think these variances should be refused because, firstly, they do not maintain the general intent of the official plan, and more importantly, there is impact upon my clients, which I've done my best to show you directly this morning.
Okay.
Thank you.
Thank you. I think I read in your submission that you would also be open to a deferral. Is that correct?
Of course, Madam Chair, we'd welcome the opportunity to chat, but that just hasn't happened for whatever reason.
Okay. Panel members, any questions for the Okay, we don't have any further questions. Thank you. So we'll go back to Mr. Romano. You have 5 minutes, starting now, to address the concerns that were brought up.
Yes, thank you, Madam Chair, and thank you, Mr. Margulies, for your letter and for your submissions. I will, at the outset, state that Mr. Margulies' client has never answered the door to the more than a handful of times that my client has approached that property. My client continues to be open to discussing the application with that owner, but certainly to hold my client hostage on a deferral when the neighbor will not discuss it with my client is difficult and not supported by my client. The comments that Mr. Margulies stated and his actual letter contradicts what he's describing as the expansive and vegetative landscaping between homes. He clearly pointed out in the letter and in his comments that the only access that his client has from the front to the back is on the north side of number 43, which means that the south side of number 43 does not have a 1.8 meter side yard setback, despite that building being on a lot that is approaching 18 meters in. So that is indicative of what is occurring on the street, and that is indicative of what's happening at number 43. Number 47 also has side yard setbacks that are smaller than the requirement under the zoning bylaw. 0.3, 0.4, 0.45 are common variance side yard setbacks that you will see in the photographs that I have on slide 1 of my presentation documents. So it's quite common to find properties that have side yard setbacks that are less than the zoning bylaw and they're not vegetated, as Mr. Margulies has pointed out. In terms of the fenestration on the north wall of number 43, there is no direct sunlight that gets into the stairwell for number 43. That wall is on the north side of the property. The sun trajectory in this hemisphere is that the sun rises in the east and sets in the west, so it passes through the southern hemisphere. It does not pass through the northern hemisphere. So the ambient light that stairwell currently receives will continue to be received. You will see that the front yard setback that is required by the zoning bylaw would similarly affect that window. The side yard setback that is being proposed is being compensated by a reduced building height and a reduced wall height on the subject property. I think those are extremely important mitigative measures that are being incorporated. And if you look at the third floor and the front elevation, that sloped roof moves well away from the side walls of the building. That allows for more than ambient light to occur within that northern wall of the stairwell. So there is no unacceptable adverse impact. And I understand that part of Mr. Margulies' submission is that there should be absolutely no impact, but that is not the test. The test under minor is whether it is unacceptable adverse impact, and that is not being shown or evidenced, and that is clearly not the case in this condition. In terms of the floor space index, existing building is currently at 0.39, and it sits beside properties that are up to 0.78. That is a condition that is common, and the points that are being made regarding buildings that are larger with smaller side yard setbacks in this neighborhood, you'll see on page 2 of my slides, we have floor space indices up to 1.0025 at number 53 Dunvegan Road. And we have building lengths and depths in excess of 41 meters, 42.75 meters. And those are on larger lots as compared to the subject property, which is a constrained lot, 9.6 meters wide in frontage. I would expect that the subject property would have a much longer length and depth for a building to be constructed upon it, but that is not what is being proposed. What is being proposed is sensitively designed, and I would submit does not create any adverse impact of an undue nature. Subject to any questions, Madam Chair, I believe that would be my response.
Okay, thank you. Panel members, do you have any questions for Mr. Romano? Mr. Clay?
Thanks, Chair. Mr. Romano, the length you're proposing, is that a consequence of the covered patio in the rear?
Yes, thank you for that question, through you, Mr. Chairman, Madam Chair. The length and depth are being measured at various points. The 22.02 meters is measured from the bay window to the rear wall of the building. The 24.71 meters, including the walkout and the covered patio.
And the walkout extends to the rear of the covered patio?
Yeah, you'll see on my, if you look at slide 1 of my presentation on the lower right, left-hand side, the image with the numbers on it and the text, that shows the covered patio on the left-hand side. Then underground, you'll see the walkout. They're basically aligned with one another.
And the
actual living space, my apologies, the actual living space from front to back is 20.8 meters in length. On the third floor, it's 18.6.
Okay. The side yard setbacks, which seem to be the main concern by most, on the north side, because the existing building looks like it's kind of articulated, but it looks like your proposal is respecting the outermost reach of the existing building, but you are extending the setback or the building on the south side to a greater degree than what the existing building is. Is that correct?
Yes, that's absolutely correct, and there's method to that madness, if I can use that term. On the north side, on the north side, what we're trying to achieve is maximum light penetration towards the north, because the sun projects towards the southern hemisphere. That's why you have the 0.9 and the 1.22 meter setback on the north side. On the south side, and even Mr. Margarita's photographs show, on that side is essentially unusable space. There's vegetation, there's a fence. Really, to make out the width of the building function properly, that is why we have that setback. So we were a little surprised that side yard setback, which would have been in keeping with what would have been permitted under the former zoning bylaw, has been a cause for concern.
And finally, I think I heard in your presentation that you have several examples where homes in this neighborhood have a setback which would be consistent with what you're proposing? Or did I hear that or not?
Yes, thank you for that question. Through you, Madam Chair, thank you, staff as well. So if you look at those photographs, those photographs do not show 1.8 times 2, 3.6 meters between buildings. That would be the requirement, 1.8 and 1.8, and those are on wider lots. In those photographs, you're going to see some properties that have 0.41, 0.9, 0.85 meters. And there are other setbacks that I see that I have in the Committee of Adjustment Research, 21 Dunvegan, 0.56 meters, 29 Dunvegan, 0.41 meters, 92 Dunvegan, 0.9, 47 Dunvegan, 0.9 and 0.9, including the length in excess of 17 meters. So they're 95 Dunvegan, 0.3 meters. Those are all on wider lots. So it's quite common to have side yard setbacks that are tight on on a new build site.
Okay, any other questions? I just have one. I'm just curious, why did you move the house forward? Because I hear about the blockage of the windows next door. I understand sometimes we do we take like an average of the two houses like on either side, but in this case, there's actually 4 houses going up, I guess 40, 45, 47, 49, and 51 that are all kind of more or less lined up. Why did you not keep it that way, and then it would have been less impact to the neighbor?
I think if you go to slide number 2 of my presentation, Madam Chair, you'll see that the actual construction that's occurring on that street is not as you've described.
Well, the new house
the only
next,
part-
but the new house next to the neighbor is set back forward a little bit. So this house is kind of being boxed in now?
No, I would disagree with that. Number 47 received a front yard setback variance in 2007. So that building did move forward. Number 43 has a front yard setback that is, and just bear with me a second, 12.52 meters. If you go to number, if you go beside number 43 to, what is that, 39, that has about a 10 meter front yard setback. Number 33 has a 7.5 meter front yard setback. Number 29 has a 7 meter front yard setback. Go to the other side, number 49 has a 10 meter front yard setback. Number 51 has an 8.5 meter front yard setback. And number 53 is about 6.5 to 7 meter front yard setback. So that's just on the same side as the subject site. I would say that the subject building today on the property is an anomaly, and what is being proposed puts it more in line with the front yard setback, that condition that's occurring on the east side of Dunvegan Road, and it is not boxing anybody in.
Okay, any other questions, panel members? If not, let's take it into committee. Mr. Nipfel.
Madam Chairman, I think the solicitor for number 43 has introduced a convincing argument. I agree with him. I think that there is hardship on the property next door to the south because of the proposed side yard setback, which frankly I think is extreme. I do think that the side yards in the area are larger than is proposed as a normal condition, and I think that this particular condition in context is really inappropriate. So I am able to support variance number 7. I was going to suggest a deferral, but Mr. Romano already indicated that he was opposed to a deferral, so I don't think a deferral is going to accomplish anything.
Okay, are there any other comments?
I'll just weigh in. I appreciate that argument, and I appreciate the comments from council with respect to 43. But I look at this neighborhood, and they are characterized by pretty large lots, pretty large homes. Mr. Romano indicated that there were several, and he cited examples of situations where the side yard setback is either equal to or even exceeds what is being proposed here. I understand the neighbor's concern, particularly with respect to the bay window. That is an issue. But this is a smaller lot, and I think the applicant is trying to generate a floor space that is consistent with the homes in this neighborhood. I have no problem with the length. And given that, at least from what I'm hearing from the applicant, that notwithstanding 43 and some of the other concerns that have been raised, that this doesn't seem to be inconsistent with the builds that are happening and have happened in this neighborhood. So I'm not opposed to this one.
Okay, any other comments? Mr. Cheng?
I'll wait till.
Hi. I think I tend to agree with Larry that the existing condition, the existing house footprint is relatively small and has been recessed from the front, and therefore, anything if you align with the existing with the building on the south side would be creating the blockage to the neighbor. For the side yard setback, it is pretty close, but then, like Larry said, this is there's a pattern that is already happening in the neighborhood, so we can't say this is something completely out of context. And the overall size of the building of the house and the rest of the numbers are also very similar to the trend of the development of this neighborhood. So it might look big comparing to what is existing now, but when you're comparing the final build form to the trend or to what's happening in the neighborhood, it's pretty consistent. So I have no objection of these variances. And it seems like we cannot really confirm whether there was an attempt to discuss about, between the neighbor, they were supposed to have a meeting, but it seems like we can't really force them to do that. It wasn't really happening. So just looking at the facts in front, I think I have no problem objecting the variances.
Okay, I actually agree with all the comments made by Mr. Nipfel and the solicitor's arguments, so I won't be supporting this application. I too would have preferred a deferral, and I do feel that this neighbor is getting somewhat boxed in by this proposal, and I do think we need to consider these things in the full context of loss of light, etc. And so I won't be supporting the application. So I'll need a motion.
Chair, I'll move approval of this application, subject to forestry condition number 1.
Okay, Mr. Cheng, you're seconding? Okay, so I will abstain to avoid a tie. And so motion to approve the application is moved by Mr. Clay, seconded by Mr. Cheng. All in favor? Okay, and Mr. Nipfel dissents, and I abstain, so that motion carries. The application's been approved. The next item is item number, Madam Deputy Secretary Treasurer, can we do these two together? I know we have a speaker on the second one, but, okay. So we're going to do item 3 and 4 together. So 340 Lee Avenue and 342 Lee Avenue. So for both of them, we have a copy of the plan of survey, site plan, floor plans, and elevations. For 340, we have 2 photographs of trees on the property. For 342, we have 3 photographs of trees. For 340, we have a revised site plan that was received in the supplemental agenda. And for 342, we have previous Committee of Adjustment decisions as well as an OMB decision affecting that property. For both of them, we have a staff report from Community Planning that's asking for conditions. And we have 3 form letters in support for number 340 from 336, 338, and 342, so both adjacent neighbors. And for the 342, we have the same support, and we also have support from 321 and 340 Lee Avenue. Do I have, and I have one speaker, I believe, for the second one for 342. And the agent, do I have him on the line, or is he the agent here? Okay, do we have Mr. De Oliveira?
Mr. Richard De Oliveira, you have been unmuted.
Hi, good morning.
Hi, I can barely hear you. Can you speak up a bit? Hello?
Hi. Is that better?
Not much, but
Sorry.
keep trying. Okay.
Okay.
Yeah, that's much better. Can you just identify yourself for the record? And then we don't have a speaker for 340, but I do have somebody for 342. So if you can do a little bit of a presentation, maybe encompassing both.
Certainly, Richard De Oliveira, representing the owners of 340 and 342 Lee. So basically, our clients have worked together to come up with a proposal for a third-story addition. They've worked together closely to improve the use of their property and their house for some needed additional space. And on 342, some needed space on the third floor and also some amenity space given the restrictions imposed on their lot based on a proposal from years ago. As you can see on the site plan, there's very little landscaping opportunity or amenity space for the property and the homeowners. And part of the proposal is some amenity space on the third floor.
Okay. Do you want us to go to the opposition and then come back to you, or did I lose you?
Through the chair, before we go
Yeah.
to the speakers, can the agent please clarify if they've revised any variances? I believe we received correspondence that for item 3, there was a revised variance 4.
Correct. There was, through our discussion with planning, we proposed a revision to the soft landscaping in the email here in front. We've made the revision. So the soft landscaping will now be 22.18%, so 12.76 square meters.
Okay, 22.18%, 12.76 square meters, and that's for 340 Lee Avenue, variance number 4.
Correct.
Okay. All right, let's go to the opposition then.
Through Madam Chair, I will try to attempt to call them. They were online, but now disconnected, so please be on standby.
Okay, while you're doing that, I'll see if my members have any questions. Anybody? Any questions for Mr. De Oliveira?
Thanks, Chair. Just to clarify, there are the variances basically the same for both? Maybe you can,
They are slightly different based on the proposals. The 342, the proposal involves that third floor deck, where on 340, I think they're primarily involving the rear ground floor deck.
so there's no
the
third
proposal
floor,
is slightly
there's no third floor deck on 340?
Correct.
Is that substantively the major difference between the two?
Sorry, there actually is a balcony off the rear, but it's substantially smaller
On 340?
of 340. Correct.
Carl?
Thank you, Madam Chairman. On 342, there, if I'm reading the plan correctly, you have a very constrained lot, and the rear yard is a triangle with soft landscaping. Is the, oh, actually, the drawing does indicate, that's the property line, so that's why you don't have a variance, because the entire rear yard is soft landscaping. Is that correct?
Correct. The lot was reduced in size years ago as part of the proposal at the rear.
So even
And there
though it-
isn't much.
Even in 342, you actually have less landscaping than in 340, but because the lot's smaller, you comply.
Correct.
Okay, thanks.
All right, we have our opposition speakers, so if we can go to them now.
Mr. David Fine or Jeremy Fine, you have been unmuted.
Hi, Mr. Fine, are you there? They're there. David or Jeremy Fine, are you there? It's your turn to speak. If you can please, if you're muted, unmute your mic.
So, Mr. David Fine, I'll try another attempt to call you, and hopefully it'll resolve the mute issue. Yep, thanks.
Madam Chairman, is Mr. Fine objecting to 340, 342, or both of them? Or do we know?
I only show them listed at 342.
Mr. David Fine, you have been unmuted. Go ahead.
Oh, I don't know.
Weird.
Mr. David Fine and Jeremy Fine were unable to reach you by email or by phone. So, Madam Chair, please move forward. Yeah.
All right.
Chair, is there written
Yeah.
correspondence from Mr. Fine?
I don't show anything in my notes, but I can tell you the address if that helps
Yeah.
you. It's 535 to 537 Kingston Avenue, so they're abutting the side, I guess. I'm looking at the location map here. I think
Right.
the backyard kind of,
So their concern would be with 342 primarily.
yeah, yeah. Actually, it looks like it kind of goes against the house a little bit and then part of the side yard.
And there's an objector in the audience to 342 as well, right? Am I correct?
There is?
I thought there was. No?
Not that I'm aware of, no. Okay.
Please leave me a brief message. I will call you back as soon as possible. Thank you.
No. All right, we've made numerous attempts by phone, email, and we're just unable to get a hold of the opposition. Panel members, do you have any further questions for Mr. De Oliveira?
Chair, maybe to you, you probably wrote this down. What was the change on variance number 4?
It is to amend variance number 4 to 22.18%, which equals 12.76
Right.
meters.
Okay, thank you.
Maybe Mr. De Oliveira, have you had any conversations with the residents on Kingston Avenue that abut sort of the side of the property there?
Our clients did make attempts to reach the neighbors on all sides here. Unfortunately, I don't have any correspondence or confirmation that they were able to have any discussions with this address.
Okay. All right. If there are no more questions, is there anything else you want to add before we go into committee?
We're happy to I'm sorry. We do have screening along the side. I'm thinking the opposition would have some concern with overlook. We've proposed a 72-inch high screening along that side on the third floor deck to provide that privacy, both from our client's perspective and the neighboring properties.
Mr. Clay has another question.
Thanks, sir. It looks like there are mature trees between your client's property and those on Kingston. Would those be helpful in serving to shield the development from those properties?
Certainly, yeah, and those are in full bloom right now, and the visibility is quite restricted.
Okay. Thank you.
Okay, let's take it into committee panel members. Mr. Nifl?
Madam Chairman, are we going to do one motion or two separate?
Through the chair, perhaps two separate, given one is amended and there are different
Okay.
conditions for both.
Okay, so let's start with 340 Lee Avenue, item number 3.
Could I move approval of the amended application with the soft landscape change to 22.18% and 12.76 square meters, and also subject to the planning department condition, planning condition also suggests that the approval be tied to plans. I think with those changes, this is a reasonable proposal. This is a very, very unusual lot. Only surpassed by 342, which is even more unusual. And I think that there's been effort made to try and blend this in reasonably well with the properties around and to not create difficulties for adjacent properties. I think it's an acceptable application, and therefore that's the basis for my approval. My motion.
Carl, would you be open to a friendly amendment? I just noticed the substantial grade change on Lee Avenue and the fact that 340 is considerably higher in elevation than 338, 336, et cetera.
Yeah.
And I just wonder if maybe there is a small balcony. It's more than a Juliet on 340. And I wonder whether screening on the south side might be helpful to reduce overlook concerns.
I think that's covered in the planning department.
I think the planning conditions were for 342 for screening. I didn't see any screening
Oh, I have them for.
conditions on 340. Correct me if I'm wrong.
Although the agent was amenable to screening. He did.
On 340, yeah.
Yeah.
I think for sure. I don't, let's just check, as Carl says, let's check plannings.
Through the chair, I believe there are conditions from community planning regarding privacy screening
For 340 or 342?
for 340.
This is
Oh, fair enough.
340, it's on the screen there.
Fair enough, thank you. I'm,
Okay, did you want to second the motion?
yes, after all that.
Okay. Okay, so the motion is moved by Mr. Nipfel, seconded by Mr. Clay, with the conditions outlined by Mr. Nipfel, and it's as amended.
Madam Chairman,
Yeah.
I've got I'm sorry to belabor this, but the planning department report, I think Larry's right, only refers to development constructed substantially in accordance with the drawings. I thought it also had one about screening. The screening is on 342. So I think,
Thought I just saw.
No,
it.
340, so planning's report
It's on
speaks to
340.
340, but
In-
doesn't speak to 342.
Oh, but we're dealing with 340 right now.
Right.
okay, so
Yeah.
340, it doesn't include the screening, so I agree with Larry. We
Through the chair, it does. The report's
does.
on the screen.
In the supplemental agenda,
It's condition number 1.
I'm in the supplemental agenda.
opaque privacy screening shall be added to the rear deck.
The report's also on the screen.
That's number 4. That's, That's 340.
Goldman.
oh, shoot, okay. Well, if you look at the added agenda, 342, what's noted as 342 is in fact the wrong address on our agenda.
Well, there's two reports. So 340, which we're dealing with right now, has screening listed in the report.
There's 340. and it
Because
does
we're
have-
doing them separately,
It
right?
does have screening, 340
Yeah,
has
I don't have
screening.
that on mine. Okay, sir, go.
We always give
Okay.
you different stuff.
Yeah, I know, obviously, yeah.
Than we're
Yeah,
doing.
yeah, I don't understand that at all, okay.
Okay, back to the motion. So the motion is moved by Mr. Nipfel, seconded by Mr. Clay, to include the condition in the September 7th planning report, which includes the screening. and it's the application as amended. Variance number 4 becomes 22.18%, which equals 12.76%. Okay, so moved by Mr. Nipfel, seconded by Mr. Clay. All in favor? That carries unanimously. Okay, and now for item number 40, I'll need another motion for that one.
So, Chair, let's get some clarification on this one, because
Okay.
this doesn't speak to screening on the third floor terrace, but it does tie to plans. So do the plans show the privacy screening on the proposed roof deck?
Looks,
Whoever gets there first wins the prize.
nah. Mr. De Oliveira, are you there? Maybe you can expedite this by telling us whether your plans have screening for
Yeah.
342?
Yes, on the third floor plan,
Yeah,
it is on there, and it's noted as 72 inches high. The third floor plan. One more. There.
the one that's on the screen shows it? No.
Yeah, yeah.
That's
it's,
one,
top of the
that's
page.
1 foot,
Yeah.
2.5 inches high. It's just a screen around the air conditioning unit, isn't it?
Yeah, 72-inch high lattice screen, but we're open to a condition on opaque screening if we want to tie that to the.
Okay,
decision,
to
we're happy
opaque
to do that.
screening, no, up to no higher than 1.5 meters. Why don't we just put it in as a condition, and then it's covered?
Sure.
Okay,
Do the motion, Carl? You did third.
okay, Carl, go ahead.
You go ahead.
So I'll move approval of this application, subject to planning conditions which are tying it to plan, and also that the third floor roof deck have opaque screening on the north side? Is it north side?
Is it the north side, Mr. De Oliveira? I just want to not have any mistakes here.
Correct.
Yes.
Okay.
And just a comment, it's good to see proposals such as this where you have two semis that are coming in together. It helps the committee, and I think it helps the residents understand what is happening in full. So thank you for bringing them forward both at the same time.
Did you want to, so the motion then is to approve the application, including the condition in the September 6th planning report, as well as a condition for opaque screening on the north side of the deck, the upper deck, no, up to 1.5 meters. That's moved by Mr. Clay. Did you, Mr. Nipfel, you second? All in favor? That carries unanimously. Item number 5, 63 Innes Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, 9 photographs of the property, including trees, covering letter from the owners, and we have a tree protection plan that was prepared by Aziz Surveyors. We have one variance before us. Is there anyone here to speak to that application? Okay, seeing none, I don't show any opposition online. Do we have the agent, or the owners, I should say?
Chair, we just having a technical issue here.
Oh,
The
Pause
wrong
for a
material's
second.
coming up.
okay, we're having a technical issue. Do you have the owner on the line?
Yes.
Yes, I am.
Okay, can you
This
just...
is Roberto.
Hi, Roberto. Are you Roberto Fator?
I am.
Can you
Good
just
morning,
stand...
Madam Chair.
Hi, good morning. Can you just stand by 1 second? We just have a bit of a technical issue here.
go on. Wait a minute.
I'm looking for the supplementary for today. There's a supplementary there? Was it that one?
What kept coming up was the one from last,
Yeah, that's the.
just the right one. Thank you very much.
Okay. Hi, Mr. Fator. Can you just tell us your address, please?
My address is 63 Innes Avenue in Toronto.
Okay, we don't need a presentation, sir. Panel members, do you have any questions on this one? We have one variance before us. Okay, we don't have any questions. We read all the material you sent in. Is there anything you would like to add before we make a decision on this?
No, just we are a family of 5 and we really like the place. So we just need a little bit of more space for the kids.
Okay. All right, panel members, we're in committee. Mr. Nipfel.
Thank you, Madam Chairman. This is a very modest application. The variance request is very small, and I don't see that there is any substantial impact on neighboring properties. I'd like to move approval of the application without conditions.
Okay, did you want to second this, Mr. Chang, or did I see your arm move? Okay. All right, so motion to approve, moved by Mr. Nipfel, seconded by Mr. Chang. All in favor? That motion carries unanimously. Your application has been approved, sir. Item number 6, 98 Ferris Road. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, a covering letter from the agent, previous committee decision affecting this property. We have forestry asking for refusal, ravine and natural feature protection, no conditions. We have opposition from number 80 Ferris Road. I don't show any speakers online. Is there anybody here that wants to speak to 80 Ferris Road? Okay, seeing none, do we have the agent on the line?
Yeah, hello, good morning. This is Agent Imran Khan. My address is 1906 Parkside Drive, Pickering.
Good morning, sir. Panel members, we have one variance before us, so we don't need a presentation, but we do have some questions. Mr. Clay.
Thanks, Chair. So you've seen Forestry's recommendation, I presume?
Yeah.
So it's refusing. It's recommending refusal of your basement walkout. I was struggling with your plans because I didn't notice. I saw a rear walkout. Are you proposing a front basement walkout as well?
In our plan, no, we are not actually asking for any front. We have submitted the floor plan, right? There is no front walkout added.
Yeah, I'm confused too because the variance is to alter the front wall.
Yeah. So
Yeah.
so there's a variance to, or sorry, there's a suggestion that you need a variance for your front wall. Are you saying you don't need that?
No, actually, this came from the zoning examiner, right? So I have also had the same question because we didn't do any windows, we didn't do any walkout, anything, right? Just we are doing the interior alteration in the basement. So I don't know why this comment, but
Just looking at your basement floor plan, maybe we can call that up. I see the walkout in the rear to get access to the rear unit. But where does the resident of your front basement unit access that unit?
this will come from the side entrance. If you see the main floor plan, it's showing the door beside the garage, and that stair is going straight to the basement.
Oh, here.
Oh, okay, right in front of the garage.
Yeah.
Okay. So I'm struggling why we have this before us then.
Madam
If there's
Secretary Treasurer, can you weigh in? Because it doesn't really make sense.
Well, through the chair, there was
We
a
only,
zoning- Through the chair, there
Yeah,
was a
actually what
zoning
hap-
review that was conducted by the Buildings Department, and this is the variance that Buildings identified. Perhaps if the applicant can explain or ensure that the Buildings Department did review these same plans that are before the committee today.
I like to add a few explanation because in our previous building permit, what was approved last October, right? It was showing recreational areas for the owner's use, right? No second unit and whole basement, right? Now we revised the front area for bedroom and a closet, like the stair area now proposed for closet, front stair to the porch, right? Closet. I don't know, maybe this is the reason, but we didn't propose any windows and anything. Only we are having the second unit at the front wall with significant interior alterations.
So, yeah, I hate to harp on this, but the variance is asking you, it's saying that you are altering something in the front wall or the roof facing the street. Are you changing something in the front wall
No.
or roof?
No, we are not changing any front wall.
And then
because,
why is this variance here?
we should refuse the variance.
Yeah, it does. Like, why do you, I don't understand why you need this variance then. Mr. Niffel?
Yeah, I had the same question to the zoning examiner, but he mentioned this is required by law. I don't know why.
If you look at the ground floor plan, is there any possibility that that doorway that leads to the stairway is considered to be in the front wall of the building? And is the front wall perhaps determined to be that L?
Because it's just outside the garage?
Well,
Weird.
it is weird, but I'm wondering if that's the interpretation that if you look at the ground floor plan, that the front wall that goes to the corner of the foyer and then back to the garage, maybe, I'm guessing, but maybe that was considered to be the front wall.
Looks like sidewall to me.
It looks like sidewall to me as well, in which case, it's too bad we don't have the
So,
examiner here.
I don't know if we're, but my worry is that if we approve this variance, then that gives permission to actually
Alter the front.
alter the front,
Yeah.
which isn't what his plan is.
Right.
I mean, we could tie it to plans.
The plans, yeah.
We could. I mean, Forestry looked at this too, and they're recommending refusal. So based on
Yeah.
what? I'm not
I mean,
sure.
The only way around it is you approve it and tie it to plans, and the plans show that there is no access through the front wall.
I'm okay with that.
I agree.
Okay.
Okay, any other questions, panel members? Okay, sir, we're going to take it into committee
Okay.
for a decision. Anything you want to add?
No, not at this moment.
And just as a side note, have you spoken with Forestry?
No, I didn't do, mostly because that has the main building permit approved already, right, with all the exterior alterations. But we are proposing only interior for this purpose, right? So
Right.
I didn't, yeah, that was not logical to talk to them because it's only interior alterations.
Yeah, in future, I would strongly suggest when you get a refusal report that you at least make a phone call to the department to see, to explain your situation. Okay,
I just want to ask a question.
yeah, go ahead, Aaron.
Yeah, so I have a strong feeling that the urban forestry wasn't looking at the variance, but just looking at the proposed wood deck, which is within that 10-meter buffer. And this is why they come up with the refusal. Having said that, the deck has no variance. So at the committee, we cannot refuse the deck.
Oh, so you think Forestry
They
is
have to-
looking at the
they have-
rear yard?
I thought they were looking at that beautiful tree in the front because of the variance, the way the variance is worded.
That's how I can assume, because that was written on the site plan, proposed wood deck, and then there is a 10-meter buffer on the site plan. So I have a feeling that they are opposing that, but in this committee, we cannot object that because it is as of right. So what I'm trying to talk to the applicant is that even though we give you the approval tied to the plan, you might have difficulties obtaining the building permit because the examiner might flag this urban forestry condition before they can issue you the permit. So at the end of the day, you might have to modify the deck. And for that reason, I think we can say tied to the plan of the front part only. That gives you some flexibility to modify the size of the deck to meet that 10 meters buffer.
The other alternative would be to defer the application for clarification because it isn't clear. And I agree with Aaron that the forestry condition might come back to haunt the applicant. We're assuming forestry made a mistake. We're assuming the plan examiner made a mistake and that's what we've got before us. But maybe there's information missing that we're not aware of.
Through the chair, the forestry report that was submitted, dated September 1st, does state that they've reviewed the application and they request that the committee deny their minor variance to the bylaw, in brackets, alteration to front wall for secondary suite. So they do reference the front wall and secondary suite.
And it looks like there is a tree in the rear, but it's quite distant from the proposed deck.
Yeah, there's a big, beautiful
And there's
front.
there's a pool there too, right? So it feels like this is just an error. And if we were to approve it, we do have forestry's condition that they have to submit an application anyways. We could put that condition in, right? That way it just covers off. If forestry had a different intent that we're not aware of, it covers that off.
See, it also says, Madam Deputy Secretary Treasurer, it says the approval will require the removal of a bylaw-protected healthy private tree. Now, when I look at maps, the beautiful, I think it's like a maple of some kind in the front, looks like a city tree, because it's pretty close to the sidewalk. Could be wrong, but so maybe Aaron's correct, that they're referring to a private tree, which could be in the rear, but it's really unclear.
So you think that's private? It looks pretty close to the house.
Which one, the one in the front?
Yeah,
Yeah, I don't know, to me, it
I'd
looks...
say that's private.
Yeah? I
Through
don't
the
know.
chair, the memo does say private tree. Tree number 1 is a private-owned Crimson King maple.
It could be, so we're just guessing here.
Just looking at the property line here, so,
You can picture Crimson King's a red tree, so you can
yeah,
tell from the photograph.
there it is right there.
It's that one.
Yeah,
Okay.
that's it. So that's the front one. And just looking at the site plan, if you look at the site plan, the property line extends out past the trunk
Yeah, so
of the
it's
tree.
just
So it's a
inside.
private tree.
So it is the front one, then? I don't know, I'm kind of inclined to go with Carl, maybe, to defer it and have him sort this out.
Through the chair, and then in contrast, the urban forestry memo is recommending condition 1, which relates to a city-owned tree.
Right?
What the hell?
Like,
No. If you look at the condition, submission of a complete application for permit to injure or remove a privately owned tree. I'm looking at the September 1st memo. If despite their recommendation, we choose to approve it, they are recommending an application to permit a privately owned tree.
Through the chair, yes, that memo does supersede the August 24th memo that we were first referencing. So that is correct.
so there's a lot of confusion on it. I mean, in addition to the variance itself, to be honest.
Yeah.
I mean,
There's also a stair shown I mean, it only gets better. If you look at the site plan, there's a stair shown on the north edge of the porch. It's in lighter shade, so it looks as though it's been removed, but based on what it says the application is, I could quite understand the misunderstanding.
Yeah. I agree. Let's defer.
Okay, well, we need to make a decision on this, so,
Chair, I'll move deferral so that the applicant can discuss the application with forestry and clarify the intent
okay.
with
so-
respect to the front yard.
Would you consider a friendly amendment that he also discuss it with the plan examiner to make sure that the variance is required?
Sure.
Okay, so I have a motion to defer, moved by Mr. Clay, seconded by Mr. Nipfel, and that is to give the applicant a chance to get clarification, both with zoning regarding the variance itself and whether it's necessary or not, and if it is, also speak with forestry to get clarification on private tree, city tree, etc. Okay, so all in favor of the deferral? Okay, that carries unanimously. Okay, item number 7, 152 Atlas Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, 3 photographs of the subject property, presentation materials from the agent, a staff report from forestry asking for conditions number 1 and 2. Correspondence expressing concern from 154, which is adjacent, as well as 156 Atlas. Correspondence in opposition from 329R Renona and 150 Atlas, which is the other adjacent owner. And I have 2 speakers. Is anybody here in person for Atlas? Okay, both speakers are here in person. Alrighty, do we have the agent here or online?
Online, Madam Chair.
Good morning. I just need your name for the record.
Jonathan Benskowski.
All right, Mr. Binkowski, can you please give us a presentation, no more than 5 minutes? We'll start the clock. Before we do, is there anything you need staff to put on the screen?
Just my support material. We'll start off with the actual survey.
That one?
Yep.
Okay, go ahead. We're starting the clock.
Good morning, committee. Good morning, Madam Chair. This is a proposal to construct a new dwelling with a garden suite in the rear. This is a little bit of a unique site. As we can see here, it is subject to not only a right-of-way between the dwelling to the south and the subject property, but as well as an easement that goes through the property and actually extends to the west along Winona. We also see within that easement itself, there is a catch basin located at the rear. Much of the concern and issues raised by the neighbors have to do with drainage. Yes, there is a creek that essentially runs below this property. The idea behind this catch basin is that is existing and would remain unchanged, as that is part of the easement that runs through the property, is to absorb as much of that water as possible. The subject property sits at the low point of both the north and the south along Atlas. So the actual spot elevations for the subject property are the lowest point along the street. In terms of how to deal with grading and drainage, before I get into my presentation, because again, a lot of the issues raised deal with that, the proposal is for both a new dwelling as well as a new garden suite. As such, it would be subject to a grading plan that would have to be approved by Toronto Buildings. Toronto Buildings has a mandate that all water be able to be absorbed within the site itself. Now, to speak to the absorption of the water within the site itself, we do have 2 variances. If we could go to the next page, please. We do have 2 variants that relate to both front and rear yard landscaping. The front yard landscaping essentially is caused by that right-of-way that is between the subject property and the subject property to the south. We are again amenable to permeable pavers that would be located within the proposed driveway, as well as the the existing right-of-way area between this property and the property to the south. In terms of the rear yard landscaping, as you can see from the site plan that is above, that is on the screen, we have proposed permeable pavers for the proposed bicycle spaces in the rear yard, as well as a rear elevated deck that is not a concrete deck that would also be permeable. We would also be amenable to a condition that would have to be of a permeable wood material. There is a proposed basement walkout, which again would have a drain that would be connected to the dwelling sump pump system. It would also be able to absorb the falling rain. And this took a little bit longer than I expected. Turning to the variances itself, I've created a couple of graphics to illustrate the impact. If we could actually just go back to that first one, the proposed side yard setbacks are essentially existing. What we see is the existing side yard setback to the north at 0.28 and a 0.89 meter side yard setback to the south. So again, the side yard setbacks are really what exists with the existing dwelling that is there today. In terms of the height and the FSI, how they've been appropriated, if we could just move down a little bit to see the graphic I have here. What we've done here is I've shown you the two heights as how they relate to where it sits within the dwelling itself. The only main wall dwelling height that is being requested is for that area located within the middle of the dwelling that is in green. As it addresses Atlas to the front, the main wall height of the building is 7.87 meters, similar to the rear portion, which is 7.87 meters as it addresses the dwellings to the rear. If we could just continue on down, please, to an elevation. And while we're doing that, in terms of the laneway suite itself, there is no request for a rear yard setback. There are requests for side yard setbacks. This is a narrow site at essentially 6 meters. So again, in terms of where it's appropriated within the garden suite, the separation from both the main dwelling as well as the rear property line are as per the zoning bylaw. I think it's just down one more, please. Again, just to illustrate where those heights are appropriated, again, the 10.93 meters is only in the middle of the dwelling. The other thing we've done here is if we look at the rear balcony, which is a variance itself, we have set it back 1.2 meters from the rear wall of the house to mitigate any impact of overlook into the adjacent dwellings. We are amenable to privacy screening along the north and south sides at the rear if the committee would deem that to be appropriate. Again, I dealt with the landscaping with permeable pavers. In terms of the angular planes, again, with that appropriate setback at the rear being compliant with the zoning bylaw, I don't see an issue in terms of any impact, and I will, I guess, address some of the further concerns when I have more time.
Okay, great. Thanks for keeping within your time. We'll go to the opposition, and then I'll come back to you for questions. So do I have Mr. Escobedo? Okay, if you can come up to the front and just state your name and address for the record, and then you'll have 5 minutes.
Good morning.
Good morning.
My name is Gustavo Escobedo, and I live at 329R for Rare, Winona Drive. I am adjacent to the property, but through the back. Just to clarify really quickly, my house is a house behind a house. And in the materials I've submitted to the committee, you can see just how close I am to the proposed garden suite. Based on the evidence below, I hope that the committee will agree that the variance requested for the garden suite, which is what I'm here to oppose, not necessarily the house, the proposal is not at all desirable for the appropriate development or use of land or the building. The general intent and purpose of the city's zoning code or bylaw are not maintained, and the general intent and purpose of the official plan are not maintained either. The proposed garden suite has been placed at the very back of the property with under 2 meters to the rear property line that faces my home. The proposed structure would be 20 feet of vertical height and would sit in a direct sideline of my kitchen windows, which are a primary space for my family and myself. The east-facing wall of my home and the kitchen windows are only 53 inches away from the property line, so a 20-foot tall structure would block all morning light that now lights my kitchen during the entire morning and indirectly through the rest of the day. The proposal seeks a variance to dispose with a 45-degree angle to the front and back of the structure as described in the Planning Act. This would result in a 20-foot wall 100 inches away from my kitchen windows where much needed eastern light comes in all morning and indirectly through the rest of the day. No part of an ancillary building containing a garden suite may penetrate. I mean, you know what that one is, the 45-degree angle. Secondly, the proposed garden suite would have 2 second-story windows that face directly onto my bedroom and bathroom windows on the second floor and would rob my family of privacy. There would be no windows facing directly across our bedroom and bathroom window. There should be none. Again, these windows would be about 100 inches away from our house. This goes against good city planning. Thirdly, we are concerned about 8 mature 30-foot tall cedars at the very back of 152 Atlas. These trees create a privacy buffer between our kitchen windows and the neighbors on Atlas Avenue. They also create a privacy buffer between our upstairs bedroom and bathroom windows facing towards our Atlas Avenue neighbors. The proposal for the garden suite has the building take up the entire width of the property with absolutely no space on the north and south boundaries, so it would be impossible for the owners to service the cedars behind the garden suite. It would seem to me that there's zero consideration for these trees since the building proposed would be, there would be no access to those trees. Based on the current proposal, we fear that these trees might be cut down and that there is no interest in maintaining healthy trees since there's no access to that. Sorry, just a second. Based on the current proposal, we fear that these trees might be, sorry, I already read that already. 152 is a narrow lot, which is why the builder is seeking to build across the entire width. We're okay with the idea of garden suites in a location where it's suitable, but we feel that with the narrow lot and the very, very close proximity to my primary living space, that this is a very bad idea. Lastly, just to talk about the flooding and the water, there's a sewer there. Even with the sewer there has been major floods. We ourselves built our house up about 2 feet higher with the foundation in order to ameliorate that. So creating a garden suite that's just sort of a ramp without a foundation, without raising it up even further than 20 feet, would make it a very sort of foolish place to...
somewhere else now.
So that's, I don't know if you've seen the pictures, the committee's seen my pictures, and can see that it will have a very dramatic negative impact on the life of our house on Winona.
Okay, Mr. Clay has a question, and then Mr.
Thanks for coming down. Thanks for sharing. You live in a very unique situation.
Yes, sir.
So you've got a home that's kind of behind everybody else.
Correct.
I'm sure there's a history to why it's there and how it's there.
That's right. We built it about 10 years ago. We went through committee, and it was approved. And it was, yeah.
Oh, it's a new build?
It's a new build, yeah. It was an L-shaped lot.
Okay.
And we lived at 329 Winona. And then we severed the lot and then sold 329 and built 329R in the back.
So it's effectively like a precursor of garden suites?
Yes, sir.
How do you get access to your home?
There's a driveway that we have right of way that comes in from Winona between 327 and 329. You can see. I've also submitted some elevations of our house, so you can see where the windows are facing 152. I think the last page.
So was this, that lot that you're on, that large lot, was that something else previously?
No, it was just an L-shaped lot. It was an unusual, there's our upstairs windows, and there's the cedars that are at the back of the house. And again, I think the planning with having the building completely blocking access to those trees is not a good precedent.
So those trees are on the applicant's property, not yours?
Yes, they're on his property.
Okay, thank you.
Mr. Nipfel?
I had the same question about access. So there, on the location map, there appears to be property associated with 329 and 327, and you say you have a right-of-way?
Yes,
Goes between there and then somehow connects up to the property that you're on.
correct.
What is the distance between your building and the east property line, your east property?
About 55 inches. You
And
can see in the photo, there's a couple of photos there that show my kitchen windows and just how close. So basically, if you look to, I think the third photo there, that's facing north, and you can see the shed on the right. And then the next picture is actually better, facing south. That shed, that's very, very close to where this garden suite has been proposed to be put. It's really that far back on the property.
and your point being that the landscaped area behind the proposed garden suite, which has existing cedar trees in it,
Correct.
the only way to access that, frankly, is from your property.
It would if they were to build an edge-to-edge garden suite there.
Do you have access to that property now?
No, but there's a fence there.
Okay, that's a good point. Thank you very much.
Yeah, and I mean, the main thing for me is that a 20-foot structure, they're looking for a variance on the 45-degree angle, that a 20-foot structure that close to one of my primary living spaces is going to have a huge effect. Plus the second-story windows facing directly onto my bedroom and bathroom windows.
And, sorry, when you went to Committee of Adjustment on the subject property at 152, there was a garage already in the backyard, but it was a smaller garage, is that correct?
Sorry, in which?
When you went to Committee of Adjustment to get your approval?
All right, there was a single-car garage that belonged to 329 Winona.
Okay, but in terms of the application we have now at 152, was there a garage in their backyard?
No, there's just a shed there.
Okay, thank you.
Okay, are there any other questions? Okay, no more questions. Thank you very much, sir.
Thank you.
The next speaker is John Cox or Mary O'Connell, or both.
Thank you, Madam Chair and committee members. I am Mary O'Connell, and I'm speaking on behalf of myself and my husband, John Cox. Our family has lived at 150 Atlas Avenue to the south of the property for 33 years, and before that, we actually lived next door in 152 Atlas. Both of these homes were built on top of Garrison Creek. They're properties with unique challenges. I did want to mention that at no time has there been any attempt by the applicant to communicate about the plan of what he wants to build with us. To approve the variances in this proposal, they must be appropriate to the development or use of the land. This development fails that test due to the very high risk of flooding caused by the topography of the site, and hence this is not a minor variance. It's not a typical Toronto lot. 152 Atlas and 150 Atlas are the lowest point in the neighborhood that are built literally on top of Garrison Creek, the remnants of which flows through a storm sewer between 150 and 152 Atlas. At least 6 blocks in the neighborhood drain into the catch basin between 148 and 152 Atlas. The storm sewer that drains these basins is less than 50 centimeters in diameter and is unable to handle the runoff in the heavy rains. And consequently, water pools on the street to the depth of over 30 centimeters at times and courses down the alleyway between the two houses and pools in the backyards of 150 and 152 Atlas. This flooding damages our gardens and requires cleanup of litter and other filthy street debris. Most of the homes on Atlas Avenue have paved parking pads, which contributes to the drainage problem. Since 2005, there is a history of communication between the city and the residents of this portion of Atlas Avenue. In addition, a garden suite with a 37 square meter footprint, a parking pad, and a 6-meter extension of the main building will diminish the ability of the yards to absorb this runoff. The proposal shows no provision for mitigating this increased runoff. In addition, a new laneway house behind 329 Winona Avenue was completed in 2013, directly behind the yard of 152 Atlas. This large house has a sump pump that runs frequently. Constant water pump noise to maintain a property contravenes the general intent and purpose of the city's zoning code and bylaws. The proposed building plans show a rear entrance to a basement suite and an entrance to the garden suite, which both presume clear access down a narrow alleyway between 150 and 152 Atlas. As mentioned earlier, this alley is a floodway for street runoff, in addition to runoff from both houses' downspouts. In the winter, it fills with ice and snow, and in the spring melt, it is virtually a no-go zone. Previous landlords have never bothered to clear this passage. The unsuitable topography carries another serious risk and makes the proposed development inappropriate. The instability of ground at 150 and 152 Atlas, the presence of groundwater in this creek bed, and the likelihood of active underground springs has led to a significant foundation damage at 150 and 152 Atlas Avenue. Both houses have settled to an alarming degree, each leaning to an angle of approximately 8 degrees. By demolishing 152 Atlas, digging a new foundation, and disturbing the ground, there is likely to be more settling of our house at 150 Atlas and consequent damage. The proposal makes no acknowledgement of the unique and fragile ground conditions at this site, and thus cannot be deemed a minor variance. We and the neighbors have mitigated the negative effects of flooding by planting many cedar trees in our backyards. These trees were tall when they were professionally planted. They are currently healthy 5 to 8 meter trees. The proposal will require the destruction of these trees, which overlap the property. The trees will also shield us from the new buildings, as well as helping with the drainage. Reducing the mandated 0.6 meter setback to 0 meters will harm the remaining trees on our property. We also have a mature protected ash tree that is 38 centimeters in diameter, and it's less than 2 meters from the property line. Finally, variances to 10 to 13 collectively contravene the intent of the City of Toronto's new garden suite bylaw. If garden suites and laneway houses are to be embraced by older neighbors, we believe adherence to these guidelines must be followed, especially in dense neighborhoods such as this one. Eliminating the 45-degree angular planes and building directly up to property lines without setbacks violate the intent of the city official plan. These are not minor variances. If these plans are approved...
Ms. O'Donnell,
Yes.
you're way past 5 minutes.
Okay.
Can you wrap up, please?
Sorry. If these plans are approved, the rules of garden suite bylaw with property setbacks and proper angular planes need to be adhered to.
Okay, thank you. Do you have any questions, Mr. Clay? Go ahead.
Thanks, Chair. So you mentioned that there is a catch basin between 150 and 152?
Yeah.
You're at 150, right?
Yeah.
On the survey, it shows a manhole, which is a very different concept than a catch basin. But it's got one of those slotted things, and it actually catches water?
No, it is a manhole.
It is a manhole. So it's not necessarily designed to capture runoff?
No, the rain is captured on the street, I think, and then it flows through that pipe.
Okay, so there's no catch basin in the right-of-way?
No.
Okay, I just wanted to clarify that. Thank you.
Carl, did you have a question? No? Okay. Any other questions? Aaron, no? Okay. Thank you. Mr. Minkowski, are you there?
I'm here, Madam Chair.
If you could speak, please, only to the issues raised. You have 5 minutes.
Yeah, I'd like to just address the trees first. Forestry, would have conducted a site visit. They are recommending condition 1 and 2. If there would be any injury to a neighboring tree, as Mrs. O'Connell mentioned, she would be pulled. A letter would be served upon her to make comment and register objection if that's the case. I don't believe there would be any injury to the tree on Ms. McConnell's property. To deal with Mr. Azeveto's concern, the rear yard setback we're proposing is as per the zoning bylaw. If we could go to the last page of my presentation material, I indicated a small graphic, just again, yeah, that's perfect right there, showing kind of the relationship of Mr. Azeveto's property to the subject property, in addition to 2 properties to the north. As Mr. Clay mentioned, this is essentially an original garden suite that is constructed along this property. And as we can see, his primary windows essentially right now look into the rear yards of 152 and 154. The windows we're proposing that are along the rear wall of this property are not primary windows. One is within a washroom and one is at the top of the stairs. We would be happy to have a condition of frosting those, again, as they are not primary windows. All of the primary windows in the proposed garden suite face the rear yard of 152. And again, I want to stress that the proposed setback we are providing is as per the zoning bylaw at 1.5 meters. To go back to the idea of the angular plane requirement really is to kind of limit that impact of what you would see from those adjacent properties and to appropriately mass it. The dwelling is, again, as per the zoning bylaw, of 6 meters. In my opinion, having that angular plane would not change the impact, again, of a 2-story dwelling that already sits to the rear of the subject property at 152, as well as 154 and 156. To address the idea of access into those cedar trees, you don't have to access the rear of a property through a side yard setback. There could be access through and through from the subject property, which might be the case if somebody were to decide to put a door at the rear and have a barbecue within that 1.5 meter setback to the rear. Within a 1.5 meter setback, that would be, I believe, appropriate space to accommodate cedar trees, which we know are tall and often narrow and don't have the same root structure as a larger tree. Just give me 1 sec to go through my notes here quickly. Again, the height is compliant. I didn't really hear many objections with the dwelling itself. Mrs. O'Connell did mention the narrow alleyway. There is no reduction, obviously, into that right-of-way that is existing. We're actually improving the side yard setback of the dwelling from where it is today, because presently the existing dwelling does sit within a portion of the right-of-way between 150 and 152. We are expanding that and increasing that setback. In terms of flooding and drainage, how I would speak to that is, again, that is a Toronto building issue. That would be dealt with through a grading plan. And again, there would have to be demonstration that all water runoff would be contained within the site. I would also say that newer construction practices would always be an improvement over something that is there. Mrs. O'Connell also mentioned the house leaning. That is part of the reason for the new build. We did contemplate trying to do an addition and a top-up. Because of that lean and because of the structural instability, it really wouldn't be possible. In terms of the idea of saying that the zoning bylaw speaks to drainage and things like that, we can't create a property stale because of the idea of drainage. But what we can do is look for every way to improve what is already there. And through a grading plan being submitted, through the idea and the condition of the permeable pavers that we proposed, in my opinion, we would mitigate that impact. And again, in terms of that impact to the weir along Winona, we're really proposing exactly the same thing Mr. Azevedo has. Again, he has no angular plane. He has primary windows facing the rear yards of 152 and 154. Our primary windows face the interior of 152, which is the garden suite and the laneway suite guidelines of where those primary windows should face. I'd be happy to answer any questions that the committee might have at this time.
Okay, Mr. Nipfel and then Mr. Cheng.
Thank you. The rear yard setback for your proposed garden suite, that's as per the bylaw, is that correct?
Correct, Mr. Nipfel.
And I missed your explanation of how you could access that area to maintain the cedars. You lost me. You were talking about a right-of-way and going out for a barbecue, and I missed all of that.
Sometimes I get excited, Mr. Knipfel, and start talking really fast. We could just have a door. Again, this isn't a garage. This is a laneway suite. So we would just have a door at the rear of the first floor of that garden suite that could access the rear.
Okay, you're proposing that you would change the design to accommodate that?
That could be a condition, yes, to have a ground floor door along the west wall at the first floor. My point really was you don't have to have a side yard setback to be able to access something behind. It can be just through a door that would access the rear.
Okay, thank you.
Mr. Chang.
Yes. Hi, good morning. So I actually have a more fundamental question would like to ask you about the variances, the last four regarding to the angular plane of the garden suite. So you mentioned that there's no impact of not following the angular plane guidelines to the neighbors. But my understanding of the garden suite bylaw is that when the city came up with this idea of allowing people to build a secondary suite at the back, so-called garden suite, meaning there's no laneway. And there was a thorough discussion on how this should happen when your lot line is back to back to the neighbors behind. And I think one of the solutions to create that same or similar effect of having a laneway in between is to have this angular setback. So there is a very strong urban design rationale behind to support these planes. And when I look at your plans, I'm not trying to design for you. It seems like all you have to do is just to put the staircase at the back, and you can achieve that 45-degree result. So I'm just wondering if this is something you want to look at, because it's very hard for me to support that 4 variances at the garden suite.
How I would address that, Mr. Chan, is if we could go to the site, or if this is actually perfect where we sit right here. Part of the impact is really where that garden suite is appropriated on the property as it relates to both of those adjacent properties. Now, if we look at what we have on the, actually, it may be better to go to, if we could go to the site plan I've submitted.
Yeah.
If we look at where that is appropriated and where that impact falls within the adjacent property's amenity space, we see here that we have the 7.5 meter setback from the proposed dwelling. But if we look at both the dwellings to the north and the south, and also keeping in mind that the proposed dwelling's length is at 16.9 meters for the first 2 floors, which is below the zoning bylaw requirement, we can see the amount of amenity space within the rear yard of both the property to the north as well as the south. So you're essentially looking at somewhere around 35 feet to 40 feet that would be from the rear yard, from the rear wall of the dwellings to the north and the south.
I'm sorry, I'm talking just about your garden suite. I have no problem with the house at the front.
No, Mr. Chen, what I'm speaking to is where the garden suite is appropriated in terms of the impact as it relates to the rear amenity space of the properties to the north and the south, of what land they would use and what that impact would have in that rear yard. I don't believe...
Oh, I see what you mean. So I was more concerned about the west. It's the overall urban streetscape or the landscape that we are trying to achieve here.
And I agree, Mr. Chan. And again, I just would say because of that separation we have, both again from to the west, which would be the rear being zoning bylaw compliant, if we were to have that angular plane, we're really not creating something much different than what is already to the rear of Mr. Acevedo's. But as it relates to the north and the south, the impact of not having that angular plane is really mitigated by the where it is in relation to the amenity space to the north and the south.
What I'm trying to tell you is that it is not minor. You might you understand the concern that I'm having. The angular plane, so you follow the rear setback. And so the rear setback of the garden suite and the angular plane is a set of tools work together to achieve that urban planning result. So I guess my question, you're trying to tell me that this setup it's not applicable here because of the north and south. But I'm more concerned about the neighbor right behind you, or the space behind you, that whole blocks. Because if everyone is building this garden suite door to door with no angular setback, that would become a huge impact to the community, and therefore it is very hard to convince that what you're trying to do is minor. That's the argument I'm trying to share with you before we propose something. So I want to see what is your opinion on that.
I hear loud and clear what you're saying.
See what I mean? There's an implication of approving what you're trying to do, and I see that angular setback is as important as what you're trying to do at the front of the house, which I'm glad that you did that, which looks great, right? You reduce the size of the top floor, and I have no issue about the height, that little addition, right? So we're talking about the back now, the property as a whole, the extension of this property, which is the garden suite, that 45-degree angular plane. And I even look at the plans, and I think it wouldn't really impact much on your layout. I mean, on the efficiency of the space. As long as you just have to rotate the staircase to the back.
So my understanding, Mr. Chan, is the variance you would like us to remove would be variance number 12, which would be the new ancillary building containing a garden suite will penetrate the 45-degree angular plane toward the rear lot line as it relates to Mr. Acevedo to the rear.
Yes, correct. That's very hard to swallow. I have to explain. I have to share my concern with you.
We will remove variance number 12. We will comply with the angular plane to the rear.
Okay, thank you so much.
What kind of revisions is this going to require to the plans, Madam Deputy Secretary Treasurer? Is this something that needs to be recirculated or not?
Through the chair, the applicant is just removing the variance. So that should be sufficient. And the applicant can perhaps speak to the purpose of the application. I don't think anything needs to be amended in that case, but this would just be an amended application in terms of removing variance 12.
Can we clarify with the drawing that Mr. Bukowski had on the screen that showed the two angular planes, that we're getting the right one? Could we get that drawing back up again that shows?
But I thought I heard something from Mr. Cheng about reversing staircases.
Yeah, I understand.
That's just a design option he can choose to achieve the same result
That's a different
without that
issue.
variant.
But there are two angular planes. On another drawing, there's two angular planes. Now, are we removing, to make sure, is it number 11 or 12? It's the one at the back. But have we got the right variance? Is it number 11 or 12, Aaron?
I think the applicant is correct, it's the 12.
Okay.
Right. Just
No.
I think it's 11. I think it's 11.
It's
That's
11,
what-
Aaron.
right?
I think 11 is the one at the back and 12 is the one at the front.
Let me just read that one. Right, towards the rear lot line. Right, correct. It's 11.
11, so it's 11. So Jonathan, it's number 11 you're agreeing to remove, okay?
Oh yes, correct, number 11. My apologies.
Okay.
And just to further clarify, I think, I'm sympathetic to the concern about the orphan patch of land in behind and its maintenance. And you had mentioned that you could put in some sort of access door for that area?
Yeah, correct, on the ground floor.
Okay.
Okay, any other questions? Sorry, it's only members. Mr. Cheng, any other questions?
No, I think I'm ready to support with some conditions that we can discuss in the committee.
Okay, let's take it into committee then. Do you want to state your conditions in addition to the deletion of variance number 11?
I think the condition is to provide privacy filming, the windows facing the rear, and an access door to the back.
Sorry, which
I'm
one?
sorry, can you just repeat that? So the rear windows?
Garden suite?
So,
Oh,
yeah, so it's my notes. Basically, I was trying to capture what the applicant said. He's willing to provide privacy filming on the glazing facing the rear, facing the west side, and also to provide an access door on the west side to serve the landscape at the back.
He also proposed screening, he said north and south, I believe, the screening
Yes.
on the edge of the terrace.
Yes, on the main house, right.
and also permeable pavers for the driveway
And the rear patio, I think he said also.
Yes, he did.
and the rear patio, yes. And I think he mentioned that the proposed deck off the back was going to be constructed of wood,
Permeable wood,
just gaps in between the wood, I presume.
I guess. I don't know. I've never heard of permeable wood, but, okay.
Can somebody read back all the conditions?
Well, I can try. I don't know if I missed anything. So first of all, we're deleting variance number 11.
Yeah.
Permeable pavers for the driveway and the rear paved areas. A condition for the ancillary building, I believe, that the rear windows on the west side have some kind of privacy film on them. And the west side access door on the ancillary building, and then the main house screening on the north and south sides of the deck. Did I miss anything?
Forestry 1 and 2.
And forestry conditions 1 and 2, yeah.
So that will be my motion to approve with the
So,
conditions.
okay, so that's Mr.
Well
Chang.
said,
Thank you.
Aaron.
Okay, so Mr. Chang's motion is to approve with those conditions. Do I have a seconder? Mr. Nipfel? All in favor? That carries unanimously. Okay, thank you, everybody, for coming out. I hope everybody followed those conditions. Panel members, let's take a 10-minute, do you want 10 or 15?
No, 10's plenty.
10-minute break, so we'll be back at 10 to 12.
You know, that's a
Okay, we're back. The next item is item number 8, which is 103 Fern Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations. We have a neighborhood analysis and presentation materials from Laila Yavari Dart Studios, 7 form letters in support from 91, 99, 106, 107, 108, 110, and 112 Fern. Correspondence expressing concern from the neighbor at 101, opposition from 105 and 109, and we have 2 pieces of correspondence from number 105. I am showing 2 speakers listed. I'm not sure if, is anybody here to speak on 103 Fern? No? Okay, so they would be online. So if I could have the agent first, and staff, do you have the speakers? Okay, great.
And through the chair, Aaron, if you are here, could you please show yourself on video?
Hey, yeah, sorry. I forgot to turn it on. Thanks.
Okay, is the agent on the line?
Yes, I am Leila Yavari from 35 Golden Avenue.
Hi, can you please give us a presentation, no more than 5 minutes? The clock starts now, and do you need staff to put anything up on the screen?
Yes, sure. Can you put up the neighborhood analysis? You can just scroll through that, and I'll just give a brief description of the proposal. So our proposal is to rebuild the existing ground floor addition and add a second story above at the rear of the house. The homeowners have 2 young children who are currently sharing a bedroom on the second floor because the existing 3rd bedroom is too small to properly function. It's only 4 feet wide. They do love this community at Fern and they want to age in place. And in order to accommodate that, we are proposing to extend the second floor to align with the ground floor, creating that 3rd bedroom. The proposal at the rear increases the FSI from 84% to 89%. That does include part of the attic space as well. And we are maintaining the existing ground floor footprint and setback. Care was taken to propose rebuilding the ground floor addition in alignment with the rear addition of the neighbors that are attached at 101 Fern. Their 1-story rear encroaches at an angle over our property line. We're also maintaining the west side setback of 0.93 meters in order to mitigate any change to natural light exposure for the neighbors at 105 Fern, who have an existing window at the side of their house. And we are proposing a flat roof to further minimize any changes to sun exposure. We feel that by doing so, we can get that needed 3rd bedroom on the 2nd floor and maintain a fairly modest addition at the rear of the house.
Okay.
And I'm happy to answer.
All right. I think we'll hold our questions till after we hear from the opposition. If we can just go in order, I'm not sure if the second person is speaking or not.
Good morning. Can you hear me?
I can. Can you just identify yourself for the record, please?
Yes, please. I'm Vanessa Stroniak, and I'm here with Elizabeth Kovacevic, and we are at 105 Fern Avenue, adjacent to the west of 103.
Okay, we're going to restart the clock, and then you have 5 minutes.
Can you start in just 1 second? Because I just have a brief preamble. We are calling in from overseas. So far, the connection's been pretty good. I just hope it maintains as such. Just in case we drop, we have arranged with our neighbor Ann Karpinchik at 109 Fern Avenue to pick up where we left off with the statement we provided her. I hope the committee is okay with that. Should we get there?
Yeah, that's fine. I have her name written down here,
Great.
so that's good. So go ahead. We've restarted the clock.
Okay, thank you. Good morning, committee and Madam Chair. We are objecting to the minor variance, which is an overbuild to the square footage because of unacceptable adverse impact. And mainly it's the 2nd floor. It's the rear build for that bedroom, which is what we're opposing. And that is because it will block, to our understanding, we live here every day. We've been here for over 16 years, and we enjoy the light that comes in through our primary window. It is our primary window into the center living space of our home. And it's a small home. We do everything in it. I mean, We work from home, so we're in it throughout the day. We dine there, we entertain there. We're both artists, so we have ongoing projects that we use the natural sunlight for. Not to mention, but very important to us, our jungle of plants that thrive there throughout the year. And I do want to express the fact that we have spent a lot of time since receiving the public hearing notice looking at our options. And as I've mentioned, it is a very small home. It is not open concept right now. So in the back room, we do have a kitchen with 2 small windows that illuminate the appliance as well. But we can't very well do all those activities in the kitchen. We also have a front room that is quite small with a decent sized window, but there is a porch with at least a 7-foot depth roof overhang that shadows the room for all day. And so we can't very well do what we need to do in there either. So as you can see, our options are limited, but in speaking with the neighbors at 103 Fern, I mean, we have a good relationship with them. We brought them in to our home to see the light. And I think they were actually quite surprised by the fact of what the build will do and how it will block our light. And it is going to be a brick wall, essentially. And it is a Victorian-sized home. So that 2nd-story roof line is very tall. And in terms, sorry, I skipped over their options. Their options, they have a 3rd story that is partially built, interior and exterior, that we know that they can, build to code and be comfortable in to expand and meet their needs. And we also know that they have an unfinished basement that they can build, and none of that will impact us. We also don't oppose the ground floor build. I mean, go as far as you want as far as we're concerned. So, I mean, as you can see, they have options, but we don't. We've spoken to them about it, but they don't want to move forward with those options. And we truly believe that this lack of light and the fact that it will be blocked for most of the day, if not all day, will cause an unacceptable adverse impact on us, our livelihood, our daily day-to-days, our well-being. And in terms of, let me speak. And in terms of neighborhood characteristics, at least on our side of the street, this house, 103 Fern Avenue, is very large. As I said, it looms over us. And in front, it extends at least 17 feet in front. And now we are possibly going to have a brick wall that will block most of the light and our only light through our central living space and primary window.
Yeah, I think the emphasis here for us is this is our primary living space, and this is the only window that we receive natural light from that allows us to continue with our livelihood in our home. So their 2nd story will completely block all this. And that's why we oppose their build, the 2nd floor build.
Okay.
Thank you very much. Thank you.
Okay, Mr. Clay has a question for you.
Thanks, Chair. So this is the area you're concerned about is on the side. So this is a side window. Do you have any windows or doors or openings on the rear of your house?
So in the rear of the house, on the main floor, we have walls on either side of the central room, and in the back, there is a kitchen with 2 small windows. There is a doorway to the back, outside, backyard. But as I mentioned, they do not filter light into the house because of the wall. And the only other window is in the front room, which is also blocked by a wall and stairwell, actually. So there is no filtering of light. Plus the fact there is that 7-foot depth porch roof line that shadows the room anyway.
We do not get any light from any other windows into our primary living space. This window is the only source of light into our space. Does that answer your question?
Yes, thank you.
Any other questions, panel members? Okay, I'm not seeing any other questions. So Ann Karpinski was on, or Karpinzik was only speaking if you guys got cut off, or did she want to speak also?
Yes, correct.
Okay.
I don't know if she also wants to speak. I'll leave that to her.
Yeah, I'll just double check to make sure if you have her on the line.
Okay.
Okay, thank you.
Thank you.
Ms. Ann Karpinzik, you have been unmuted.
Hi, Ann, are you there? Hi, Anne. Can you hear me? I'm not sure if you've been listening. Elizabeth and Vanessa were able to speak. I just want to make sure you don't want to add anything for yourself, if you're there. Okay. All right, I'm going to go back to the agent then. Do you have the agent on the line?
Yep, I'm here.
Hi, can you speak please to the issue raised?
Yes. I'll respond to there's a letter of concern in there as well, and the 2 objections. One of them is from Anne, who you just tried to reach. I'll just start with the letter of concern and then move on from there. I think there were fair concerns from their attached neighbor regarding the structure and the foundation. And we are proposing to install a new structure on the side of the shared existing wall. That way we can install new foundations and the structure minimize any effect on the neighbors at 101 on the shared side. We also intend to waterproof and seal them as one building. The exact details of these things will be developed as we work through them through the structural and the permit stages of the design. I do understand that one firm wanted our homeowners to sign a memorandum listing these statements in a letter of concern in order to get their support for this hearing when they were approached, but we did advise them not to, mainly because there are some points in there that we just can't guarantee. For example, there's a point number 5 that no excavation will be taking place at the back of 103 Fern, which just is impossible to abide by. We will need to excavate for footings in order to build the 2nd-story addition. That being said, there are other points. There are things that are already going to happen. Permits will be obtained. Homeowners and contractor will be insured. Engineer will be involved, as well as the city inspector. I'm just going to respond to 105 Fern, and I believe 109, which is 3 doors down, who's supporting 105 with the issues of the sun and the window. Our clients, the homeowners at 103, did express their desire to minimize this rear addition in order to mitigate any changes of light to 105. They do value their relationship with the neighbors, and they did try to resolve their grievances prior to this hearing. We did actually look at options to keep the existing exterior and add a 3rd bedroom in the attic. However, this required a change in the stair location, structural, the roof being rebuilt at the back at a higher elevation to accommodate usable headroom, and just an overall much larger budget than our clients can accommodate for construction. We also did look at options for underpinning the existing basement and adding a bedroom there, but at the end, it's just really undesirable solution for a young child bedroom to permanently be in that basement. There were a few other points in there that they didn't speak on, but are in the objection letter, I think from page 3 to 4. In response to the various quotes and authorities cited on those pages, they appear to be either matters of opinion or court cases concerning the law of trespass. Some are also from other jurisdictions in the UK. I can't really respond to these as I'm just trying to address the zoning issues. And we definitely do sympathize with their concerns that they raised regarding their narrow primary windows and their porch cover at the south and north sides of their own house. And their floor plans that cause issues with light in their home. However, I'm not sure how we can address those things with our renovation. And I think 109 Fern also added an objection regarding laneway concerns. We do understand that what happened to them was very unfortunate. I believe we had an incident with a past contractor doing construction on another house. We work with a handful of reputable contractors who respect laneway rules and understand the frustration construction brings to the neighboring properties, and we're confident that it will mitigate any disruptions to the laneway and work with the neighbors on the properties to assure a smooth process. I'm happy to answer any questions the committee may have.
Okay, let me see if there are any questions. Okay, I'm not seeing any questions, so we'll take it into committee. Mr. Nipfel.
Thank you, Madam Chairman. I have sympathy with the 2 ladies next door. It's unfortunate that so much of the light to the most used portion of their house comes from that particular window. I think we might be overestimating the amount of impact that this particular addition will have on that light. I do look at the proposal and think that it's reasonable. I don't think that the variance is out of line. I don't think that the options for expanding the living space on the subject property 103 are limitless, other than going into the attic, and as the applicant indicated, there's an incredibly larger budget associated with that. So I frankly think that the variances that are before us are reasonable. The one variance is reasonable, and the other thing is there is a slot of land between the east side of the 105 and the proposed second floor addition. So I'm inclined to support the application. As I say, I think it's unfortunate that it has any impact on the property to the south or to the west, but that's the very nature of development these days. So I'd like to move approval of the application without any conditions.
Okay. Do I have a seconder for that motion? So a motion to approve, moved by Mr. Nipfel, seconded by Mr. Clay. All in favor? That motion carries unanimously. The next item is item number 9, 109 Atlantic Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, covering letter from the agent, previous decisions by committee affecting the property, a tree inventory prepared by Authentic Tree Care, Inc., and we have correspondence from transportation, and they do not have any concerns. And I don't show any opposition speakers. Do we have the agent here or on the line? You're here? Okay. Come on up.
All right, thank you. Good morning, committee. My name is Daphne Goxon from Evans Planning. I'm the representative here for KI Toronto Showroom, which is a proposed tenant at 109 Atlantic Suite 303. Joining me today is John Mills, who's from KI Canada. So as mentioned, the project site is at 109 Atlantic Avenue, Suite 303, which is in Liberty Village. It's on the top floor of an existing 3-story building, which is shown in the image on that cover page that's on the screen right now, which is the building has frontages on King Street West, Atlantic Avenue, and Snooker Street. Some of the other tenants in the building include a West Elm retail store on the ground floor, a Chipotle restaurant on the first and second floors, a talent and marketing agency on the third floor, and another furniture showroom on the second floor, as well as some other office tenants. So KI is a global office furniture company that began in 1941, and their customers are primarily governmental agencies, educational institutions, and large office and institutional users. And they do have showrooms in some major cities around North America where potential customers can tour a selection of their products. If you could go to slide 3 here, you can see the proposed floor plan. So the KI showrooms are not open to the public, and they are by appointment only, and they'll generally schedule about 5 to 6 appointments per week with a group of about 3 to 4 people that would be involved in the company that might be interested in purchasing the furniture. The showrooms also operate as offices for the local staff who work full-time on a variety of office-related functions, and they'll generally be about 2 full-time and 3 part-time staff working in this office as well. So in addition, the showroom staff do not take any orders on site. Basically, they're a place where potential customers can come, tour the facility, look at some of the offerings available, and just get a feel for the products. All of the purchasing would then be handled through a dealer or a distributor who would then filter the orders to their headquarters in Pembroke, Ontario. So although the proposed project is for a showroom, the actual function is more similar to an office than to, say, like a Leon's or the Brick, which is what you might think of when you think of a furniture showroom. If you go to slides 5 through 7, you can see some images of some of the other showrooms. So this is New York, this is Atlanta and Chicago. So you can see that really they look like an office. So why are we here today? There have been 2 minor variances previously approved on the property, which, as was mentioned, was included in your packet. The first, which was approved in November 2006, authorized alterations to convert the existing mixed-use building into a retail office space, including the conversion of an existing loading area to retail space. And of specific note, this application permitted all the uses identified under the heading retail and service shops, which were previously not permitted by the underlying zoning bylaw, and also it determined that King Street West was determined to be the front lot line. And essentially, both of these variances serve the purposes of permitting retail and service uses on the property. However, one of the conditions on that approval is that retail and service shop uses be restricted to the ground floor only. Since a showroom is considered a retail use, therefore this variance would essentially prohibit a showroom from being permitted above the ground floor. It is worth noting that there's nothing in the official plan or zoning bylaw which restricts retail and service shops to the ground floor only, because the frontage is determined to be King Street West. And so this was just a condition that was added to this approval as a qualifying condition of the variance. There was a second variance approved in 2017, which did have a condition that allowed all retail and service shops to be permitted on the lot. However, that variance was specifically for a restaurant. As mentioned, there is a restaurant that's on the first and second floor of this building. And so although the qualifying condition, the condition of that variance does not specifically state that it is only for the restaurant, it was the interpretation of the zoning examiner that essentially that condition and this approval only applied to the restaurant and not to any other tenants or any future tenants. So we're therefore here before you today basically to request a variance to permit a change of use from an office to showroom on the third floor of the existing building. And again, the only reason that we actually require a variance is because of a condition on a previous minor variance that if King Street West is determined to be the front lot line, as was stated in that same variance, then there's no reason in the zoning bylaw or the official plan why a showroom would not be permitted. And also, as mentioned earlier, it's evident from the floor plan and from photos of the way that KI operates that this operation will look like an office, feel like an office, and it won't have the same impacts that you might think of as at a retail store where there's the public coming in and there's a lot of traffic and impacts from that. And also wanted to add that the previous location of their showroom was on the ground floor of a building, and it was not a good location for their operation because customers were constantly trying to come to the front door and had to be turned away by staff since it's not open to the public. So we are here for questions, sort of a weird and complicated variance for something somewhat simple. So we're here if you have any questions.
Mr. Niffel.
Did I hear you say that there is a showroom on the second floor?
There is.
How did that get approved?
We're not sure.
Oh, it's not you?
No.
Oh, okay, thank you.
Any other questions, panel members? Okay, if not, let's take it into committee for a decision. Mr. Nipfel?
Thank you, Madam Chairman. I have no trouble with this application at all. I think in many respects it's a technical amendment. I think the language got in the way. I don't frankly see that there's any problem at all with the showroom located as proposed, and I'd like to move approval of the application without condition.
Okay, do I have a seconder? Mr. Chang, all in favor? Okay, that's approved. Thank you.
Thank you so much.
Thank you very much.
Item number 10, 31 Elmer Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, a revised site plan, and then another revised site plan in the supplemental that came yesterday, 10 photographs of existing site conditions and trees on the property, email correspondence from the agent, email correspondence from the owner, again, came yesterday, arborist report by consulting arborist, staff reports from forestry. They're asking for condition number 2. They also had an advisory report. Planning is asking for conditions, and they also have a revised site plan. Transportation was asking for refusal or conditions. And I believe that the bicycle parking has been put in, and that's in the new site plan. Correspondence in support from number 29. And I am showing one speaker in support. I'm not sure. Are you Noah? No?
I'm the agent.
You're the agent. Okay. Do you have that supporter on the line or not? No? Okay, thanks. Okay. I need your name for the record. Not sure if we need a presentation. I'll check with the members after we get your name.
Ozren Stambuk.
Okay. Panel members, do you need a presentation or do you want to go to questions? Okay, questions.
We have a revised site plan in the supplementary agenda. What's been revised?
So the site plan that we wish to use as the correct site plan is the one dated August 28th that is showing the bike park, this one exactly, that is showing the bike parking, because this came as a result to our discussions with planning, and they wanted bike parking shown in the side yard. So that was the major revision that is based on their condition as well, of tying us to that bike parking and the walls and roofs of the garden suite.
Okay, thank you. In future, if you send us a revised site plan, it's helpful to just give us a note to tell us why it's there, because we get them late at night after we got used to the other ones.
Absolutely.
Mr. Clay.
Thanks, Chair. I just wanted to talk about the parking situation. I mean, you're aware of transportation's comments. Is the pad on private property, wholly on private property, or is it partially on?
It's wholly on private.
It's on private property.
It's private property, and that was part of my confusion with their recommendations. So if you feel like you have to tie us to the plan, to the transportation recommendations, then in that case, we would like to remove variances 12 and 13 and not show the parking in the front yard. But as I understood it, if it's wholly on private property, that parking pad, I felt like this was a mistake by transportation to impose all these conditions when it's absolutely has nothing to do with City Boulevard. So that was my understanding of the bylaw, but maybe I checked this also with the zoning examiner. They said that to check with transportation. Transportation is of one opinion, but I think what's being showed there is really sensible because it's speaking to an existing situation. But we are ready to be flexible on that because we do not want to now postpone this application, and we are ready to remove variance 12 and 13 because variance 13 is being triggered by us showing this realistic, genuine spot in the front yard.
Sorry, stop you. We don't have a variance 12 and 13. We have 10 variances. We have by the notice. I need you to tell me,
There's a revised public hearing notice that was sent out, and that has variances 12 and 13, and they are starred.
Okay, hold on. Let me see. I don't have that. We don't have that. Not even in the supplemental. I don't see it.
Okay, because it is on the AIC, but we can then, if...
So then committee's got has been looking at a different notice.
That's okay. Then if we don't want to create any slowdown, so we can go to the original notice and we can ignore all those changes that came from the revised notice. Because we did submit a revised notice, and we did get, like I got in the mail, this revised site notice, public hearing notice. But it kind of works.
Okay, can I just clarify with my staff what went out then? Because...
So through the chair, there was a revised notice that was sent out, and it should have been in the agenda package. It is on the AIC. Staff have pulled it up on the screen now, and it does show...
So is everything the same except for the two last variances?
No, there's 11.
Or is there other...
Isn't there?
Oh, there's no 11 even on the notice, so they numbered it wrong. So there's 2 additional variances, and the rest is as per what we have?
The agent can confirm that?
Yes, absolutely. Everything else is
identical except for the last 2. So they should have been labeled 11 and 12.
Yes, but they're 12 and 13.
Yeah, okay. So you're suggesting that those 2 would be removed, but then as per the notice, there's also variance number 9 that also talks about the width of the parking space. Would that also need to be removed?
No, that needs to stay because if we provide as of right parking on the lot, it will be a reduced size as of right parking. So that one is essential.
I see. So technically, you're saying you don't need those 2 variances that were added. Is that what you're saying?
We don't need them in the sense that it provoked this planning letter saying refuse it or impose these conditions. That we cannot work with those conditions or refusal. So if the planning report is being adhered to, then we are happy to remove variances 12 and 13. But I just had a different understanding of what we were requesting because
Sorry, can you put that back up, that notice, please? Those
Yeah,
last two
sorry,
variances, because one speaks to, like, it speaks to landscaping also.
Yes, which is being triggered by the fact that we're showing parking in the front yard, which is different from front yard parking because it is wholly on our property.
But wouldn't you still need the landscape variance?
No, it's only being triggered because of this showing of the parking pad.
So, boiling it all down, practically speaking, if you remove those two variances at the end, are you still going to be parking where you propose to park?
We will still be parking there because you are by law allowed to park anywhere on your driveway if it leads to a parking spot behind your front wall.
Right.
So for simplicity's sake, we can remove 12 and 13 to make your work easier.
And you'll be parking wholly on private property?
Wholly, yes.
Okay, and it's an existing condition, you've got an existing driveway, you've got an existing curb cut?
Yes, existing, everything is existing, landscaping is existing.
Okay.
And the transportation report wouldn't apply.
It wouldn't apply anymore.
Nicole, do we delete them as 12 and 13 since they're listed as that?
Through the chair, yes, technically, since there was a revised notice sent out.
Okay.
Well, we can clarify for the record that it should be numbered as 11 and 12. We'll put that in brackets as a note for the minutes, and when we amend.
We'll delete 12 and 13?
Yes.
Okay.
So there's no 11?
There is no 11.
All right.
Okay.
And perhaps the purpose, can the agent comment if the purpose of the application needs to be amended or not? It says to maintain the existing south side parking space.
It will still be on the south side and it will still be existing, so it doesn't need to be driveway.
Okay.
And then through the chair, just to point out the rest of Transportation Services condition about should the committee grant the minor variance application, there's still two conditions related to obtain a paving permit to restore the obsolete driveway and to submit a front yard parking.
But they wouldn't, for starters, they would not be restoring the driveway because they're going to use it. And then you wouldn't need a permit because you're on private property, is that correct?
Yes, absolutely.
So that wouldn't apply, okay.
Can I suggest in the purpose, it would make more sense, if you leave it as it is, I think it's going to trigger all sorts of argument. I think it should say also to maintain the driveway on the south side.
Yes.
Because it's a driveway, and the applicant's point is that if you park in a driveway leading to a parking space, it's considered a park. So I wouldn't call it a parking space in there.
What about the south side driveway and parking space? Or just, well, I guess, and driveway could work too.
Yeah.
And you're not planning to do anything different with the driveway? It's staying as is?
Yes.
Okay.
Through the chair, so to amend the purpose to state to maintain the driveway on the south side, including the existing parking space?
Yeah. Does that work for you?
Okay, yeah.
Okay. All right, and then, okay, and you're okay with, and you understand the rest of the planning condition. I know you've complied with the bicycle space, but you're okay, with the rest of it.
Absolutely, and just the owner has made a good point. We would really like to avoid any complications, so we're removing 12 and 13, and we would just like it stated that the driveway will be maintained, because if we put in parking space, it may cause us problems down the line of what is a parking space size, things like that. So if that can at all be adjusted, that would really...
So you want it just to say driveway
Yes.
be maintained and remove parking space?
Yes, please.
Yeah, that's fine. Okay, and you're aware of the forestry condition?
Absolutely.
Okay. And the advisory report, you've seen that also?
Yes, but just to note that advisory report actually speaking to things that are already in our forestry arborist report, we're already agreeing with those items. It was
Okay.
just, yeah.
Fair enough. It's not a condition for us anyway. It's just an advisory report. Okay, panel members, anybody, any more questions? Mr. Clay?
No, we haven't even talked about the garden suite. Which you're requesting a series of variances, but I think the design is actually quite nice. You're not, I don't think you're seeking variances from setbacks either the rear or the side. It's just angular plane and such. And I thought the design, being a slope roof, was an innovative way of dealing with that. So I think, you know, after all our discussion, I think this is a pretty supportable application. I think it meets the city's objectives for garden suites. I'd like to move approval subject to forestry condition number 2. You've seen the forestry advisory memo as well?
Yes.
Okay. And planning conditions, which basically tie it to plans. Site plan and all the elevations. So let's just tie it to all plans. And I don't think we need to include the transportation conditions. Is that what our consensus was?
Yeah.
Okay.
And then you said it as amended, right? With the deletion
As amended,
of
yes,
12
thank you,
and
Chair.
13.
Yep.
Okay, so with those conditions, Mr. Clay moves a motion to approve. Do I have a seconder?
Aaron, do you want a second?
Yep, he does. Aaron, I think I saw your hand go up. So motion to approve, moved by Mr. Clay, seconded by Mr. Cheng. All in favor? That carries unanimously.
Thank you.
Item number 11, 141 Jeffrey Street. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, revised site plan, floor plans, and elevations. Then in our supplemental agenda, revised garage floor plan, email correspondence from the agent, and a second piece in our supplemental agenda, arborist report by Scenaria Urban Forestry Services, tree protection plan by the same company, tree removal application, presentation materials received in the supplemental agenda from the agent, and forestry is asking for condition number 2. No objection. Speakers, do I have the agent on the line? Oh, you're here, sorry.
Yeah, sorry.
Okay. And are you the owner then?
I'm
You're
the agent. My wife Jen is the owner. Yeah.
Ah, well, there you go.
Yeah.
You guys are
That
covered
can
all the
be-
way.
Yeah.
Okay, I don't think we need a presentation, but if you could just state your name for the record.
Yeah, it's John Hibbett,
Okay, and your address?
141 Jeffrey Street.
Okay. Panel members, do you have any questions?
No.
We have 2 variances. Mr. Clay?
Thanks, Chair. I'm just looking at your site plan. So you're a little light on your rear yard landscaping.
Right.
But I do notice that you've got a driveway extension, which gives you access to your new garage. So are you planning to use permeable materials for that? Permeable pavers?
We'd be open to that. Yeah.
I think that would help.
Yeah, I mean,
The fact that you're a little light on rear yard landscaping, I think it would, permeable pavers would contribute to water permeability.
Yeah, I mean, I think that's kind of triggering the lack of soft landscaping is the driveway extension. So we'd be open to that.
Okay.
Any other questions, panel members? Okay, we're actually ready to make a decision on this. Is there anything you'd like to add that's not in the materials that you think is important for us to know? Okay. No? All right. Let's take it into committee then. Aaron, did I see your hand move, or am I just...
Yes. Yes, I would like to make a motion to approve the application with the condition of having permeable paving for the new driveway.
Okay, and forestry number 2.
Forestry number 2 as well, correct.
All right, that motion is seconded by Mr. Nipfel. All in favor? Okay, your application is approved.
Thank you.
Thanks. Item number 12, 497 Manning Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, revised site plan, 4 photographs of the subject property, covering letter from the agent, as well as presentation materials from the agent. We have revised presentation materials from the agent received in our supplemental agenda, email correspondence from planning, and we have correspondence in support from 499 and 497, both adjacent neighbors. Is the agent here or online? You're the owner. Is your agent online or he's here? Oh, okay.
Yes, but I'll be.
You're speaking.
Yes.
Okay, I don't think we need a presentation. We have one variance before us, but if you could start by stating your name, and then I'll see if we have any questions.
My name's May Tam. I'm the owner of 497 Manning.
All right, panel members, do you have any questions for Ms. Tam? Okay, I'm not seeing any questions. We're ready to make a decision, but if there is something you want to add that's not in the materials, we have seen all the materials that you sent in.
My materials basically outlines everything I want to do.
Okay, thanks. All right, panel members, let's take it into committee for a decision. Mr. Clay.
Thanks, Chair. I thank you for coming down. This is a very minor application. It is simply putting a second story over an existing one story in the rear. So I do note that the adjacent neighbors are already well extended into the rear as well. So it looks like you're just sort of matching up with what the neighbors are doing. I don't think it'll any negative impact on your neighbors or the neighborhood. It's a straightforward application. I'd like to move approval with no conditions.
Seconded by Mr. Nipfel. So motion to approve, moved by Mr. Clay, seconded by Mr. Nipfel. All in favor? Okay, that carries unanimously. Thank you. All right, item number 13, 700 Crawford Street. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, 2 photographs of the property, as well as a previous committee decision affecting the property. 2 variances before us, no objection speakers. Do I have the agent online?
Hello, good afternoon, Madam Chair and committee members. I'm Eddie Perez from EKP Design. I'm here on behalf of the owner. As you stated, there's 2 minor variances. If you need me to answer any questions, feel free to ask. Thank you very much.
Okay, let's see if the panel members have any questions. Mr. Nipfel.
Thank you, Madam Chair. Mr. Perez, your 3rd floor balcony, am I understanding your drawings correctly that you're extending the wall so that it blocks the view to the adjacent property?
No, yeah, that's correct.
And it shows on the side elevation, correct?
Correct.
Okay, thank you.
Any other questions? Okay, seeing none. Mr. Perez, anything you want to add before we take it into committee for a decision?
No, this application is very minor in nature and it meets the forecast. Thank you very much.
Okay, we're in committee, panel members. Yeah, go ahead.
Carl, do you want to go?
So
I'll go. I'm closer. I'll do it this one. It's a very straightforward thing. I think this is an acceptable application. It's a very modest addition to the rear 3rd story. And as the agent said, the plans are showing screening. So I think maybe, do we want to tie it to plans?
Sure, that'd be great.
I think because of the screening issue, I think maybe what we'll do is I'll move approval, but we'll tie it to the elevations.
Okay.
I think we should clarify that there's an existing balcony, a really big one, that doesn't have screening, but I don't think it's appropriate to ask for it to be screened at this time. It shows on the 2nd floor plan the proposed balcony is on the 3rd floor plan. So I'm happy to second the motion.
So you're okay with that condition to tie to the elevations, or you wanted to add something?
No, I think it's fine. I'm I'm concerned that somebody doesn't, unless the committee wants to put screening on the second floor balcony, terrace, I don't think that's our intention. I just was trying to clarify that if you look at the second floor plan, it's not that area that we're talking about screening. If you look at the third floor plan, it's that little balcony on the third floor, and it's already screened with, the proposal includes screening, and Mr. Clay's motion calls up the screening from the drawings.
Okay, so the motion then is to tie it to the elevation plans, and that's to approve the application with that condition, moved by Mr. Clay, seconded by Mr. Nipfel. All in favor? That carries. The application's been approved. Item number 14, 107 Fern Avenue. We have before us a copy of the plan of surveys, site plan, floor plans, and elevations. 2 photographs of trees on the property, and quite a bit of support. Number 80, 111, 121, 91, 98, 103, 108, 110, 112, and 115, and 113 Fern, and 100R Garden Avenue, and 110 Garden Avenue. Opposition from 109 Fern. And I'm not showing any opposition speakers listed here. Is there anybody here that's speaking to Fern Avenue? No? Okay. All right, do we have the agent?
Sorry, I can't hear you.
I think I'm on. I couldn't hear you, committee. Sorry.
Yeah, it
Through
was
through the
all
chair.
muted.
Through the chair, sorry, it appears we're having some technical difficulty where it's not being broadcasted at the moment. So if we could just
Can you hear
stand
me
by,
now?
sorry, if
Yep.
everyone could just
Yep,
stand
okay,
by.
I think
for a
you and
minute.
I can talk, but not the committee.
Yeah, it's fairly interesting. Yeah, there might be some gap in there.
Can you hear me now, Aaron?
Yes, we can now, yes.
Okay, you did hear that
You
the
might have to repeat.
the last
Yeah,
one
you might
was,
have to
you think I need to repeat everything, or?
The last 1 minute, I would say, it was all
All right,
muted.
I'll repeat it, that's fine. Okay, so the next item, 107 Fern, is item 14. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, 2 photographs of trees. We have support from 110 and 100R Garden Avenue, as well as 80, 111, 121A, 91, 98, 103, 108, 110, 112, and 115 and 113 Fern Avenue, and opposition from 109. I don't show any opposition speakers. Do I have the agent on the line?
Yes, good afternoon, Madam Speaker and committee members. My name is Bruno Lopes from MXL Engineering, located at 1649 Sunflower Avenue West.
Hi. I don't think we need a presentation. Any questions for Mr. Lopez?
Chair, I was just looking at the supplementary letter from 109.
Yep.
They appear to indicate that their original concerns have been addressed.
Okay, great. Do we have any questions for Mr. Lopez? Mr. Nipfel?
Thank you, Madam Chairman. My apologies, I'm having more technical difficulties here, but I recall in going through the agenda, the supplementary, there was a letter from 113 Fern, and the gentleman that wrote the letter said that he had a commitment from you that you would provide eaves troughs and no grade changes to the side and rear yards of the property. Does that strike you as, does that remind you of a conversation, and would you mind having a condition that paraphrases that added to any approval that you might get?
Through you, Madam Chair, this kind of commitment could be made out with the homeowner. To be honest, I wasn't aware. I was aware that we had the entire neighborhood in support, which is 15 letters from front and left and right of the property. I wasn't fully aware about this particular unique condition, but I would believe that if it states that they spoke with the owner, we're gonna honor it.
Thank you.
Okay, any other questions, panel members? Okay, Mr. Lopez, we're ready to take it into committee. Anything you want to add that's not in the submissions that we need to know?
No, just one last note that this is a very modest application. It's very similar to the one that the committee just previously approved a few minutes ago, 103 Fern, very look-alike. And it fits the neighborhood, and that's the reason why we have so many letters of support.
Okay, thank you. Let's take it into committee, panel members. Mr. Clay.
Sure. Again, this is a fairly straightforward application. It's a modest front and rear additions. I would agree with the agent. It is a minor request. The variances before us are very minor, just little tiny slivers. So I think it's a supportable application. I'd like to move approval. But I would like to tie to plans, and the reason being is that the rear balcony shows on the elevations the screening on both sides.
Okay, do I have a seconder for that motion? Mr. Cheng, so motion to approve, moved by Mr. Clay, including a condition to tie it to plans, seconded by Mr. Cheng.
Madam Chairman, or
Yeah.
through you to Larry, I found the objection. It was from 113, and it reads as following. A conversation with my neighbor and their subsequent email states that they will look after water runoff by having eavesdrops on the house as well as not having any grade changes to the side and the backyard. I initially thought we should add that as a condition, but I'm now concerned that it's so specific it might hold up an approval. So I'm wondering is there a way of putting just a note in the minutes that indicate that there'd been an agreement between them?
Like,
If we put in the condition, the wording is just very specific.
but
And we
that's
don't
not
have
a
the gentleman here to
condition.
confirm.
I don't think that's a condition we can put in anyway, eavesdrops.
Through the chair, no, that's a private agreement between landowners.
Can you put in that we understand there's been? No, and the gentleman isn't. Okay, fine, I'll let it go then.
There's a YouTube record of it.
Yeah.
Yes, thank you.
All right, so are you, okay, so the motion was then to tie it to plans to approve the application, moved by Mr. Clay, seconded by Mr. Cheng. All in favor? Okay, that carries unanimously. Item number 15. 297 Delaware Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, 4 photographs of the property, correspondence from the agent as well as the owner, previous decision affecting the property. We have a deferral request from the agent, correspondence in opposition from 295, which is adjacent, from somebody living at 297, 290, 295, the other adjacent neighbor, 289 and 290. Actually, 2 different people from 289 objected. I am showing 2 objectors, and I believe one is here. And do you have the second one online now? Yeah? Okay, and the agent, is the agent online or here? Online? Okay, so if we can go to the agent first.
Back again.
Hi, hi, my name is Bak Ding. I am the agent for the owner at the etc. 297 Delaware Avenue.
Okay, hi. Can you please state the reason why you want a deferral?
So the reason for deferral, because we had a couple of concerns from the neighbor, and the size were posted like not long enough because of someone removed the size. So over the weekend, the long weekend, the owner put the sign inside the house, and there's only another sign on the window, but it's not visible according to some of the neighbor, and some of the neighbor have the concern. So we want to defer to work with the neighbor to find the solution for the approval.
Okay, so you're saying that you will undertake, if you're granted a deferral, that you will set up a meeting with the neighbors to discuss your application, and you're going to repost the signs. Is that correct?
Yeah, that's right.
Okay, I'm going to go to the objectors, see how they feel about the deferral. So I'll go to the person who's here first. If I could have you identify yourself for the record, please, and your address.
I'm Celia Hart, and I live at 295 Delaware in the upper unit.
Thank you. Sorry you've had to wait this long, but the other person wasn't online this morning.
He was, but it didn't seem to show.
Yeah, sorry about that. In any case, how do you feel about a deferral request?
Well, I actually had also requested a deferral, although we'd prefer there be a refusing of an application. We could use the extra time, and it would be nice that finally the neighbor has the decision to actually talk to us, because we've had no discussion with the neighbors at all before their first application and before this application. So we welcome the opportunity to see if we can resolve things.
Yeah, it's always, unfortunate, and committee members are always encouraging them to do this before they come here, because it saves everybody a lot of time and effort and potentially gets rid of objectors. So, and again, apologies you had to wait this long.
Thank you.
All right, if I could have the second speaker, please. Thanks. Hi.
Hello? Can you hear me? I'm not sure if you've got me clicked in or Madison.
Yeah,
We're both at the same
you're
address.
clicked in. Are you Mark?
I am Mark, and I'm at 290 Delaware, and my partner Madison is here as well, who would like to speak.
Okay, so I don't know if you've been listening all day. Unfortunately, I don't know, technically we couldn't connect with you this morning. The applicant is asking for deferral. The neighbor, I'm sure you know Celia also, has just spoken.
Yes.
She's in favor of deferral. So they're asking for deferral. They're going to undertake to consult with the neighbors to potentially look at revisions to the application. I don't know what'll come out of it, and to repost the signs. So I'm only dealing with the deferral right now and just wanted your take on it.
Yep, and I think that is great. I had also requested deferral as well. Before I can support it, I just got an outstanding question that might have some weight on whether I'm in support of the deferral or not. I've asked other staff, but I've been told that the only people that can answer my question are the committee themselves. And it just has to do with some inconsistencies in the application regarding a side bump out that's being marked as existing, and that the third floor is existing as well. I don't see that as variance. There was a committee decision, the previous one, that was tied to a set of drawings, a set of plans, and yet what is being constructed and what's being proposed for the second level and the third level are being marked as an existing south-facing bump out that I don't see anywhere here as a variance, and I just see them called out in the drawings as existing. So I'm just wondering if someone can respond to that so that I understand if this is something that needs to be heard, or if a variance needs to be added, or if a deferral needs to be made so that more time can be put in to review this.
I mean, I'll defer to staff, but from my perspective, if there's something inconsistent or that you see as potentially needing a variance, I don't know, then that's something you can discuss with the applicant when he meets with you. But I'll ask staff to weigh in on this also.
Through the chair, it is up to the applicant in carriage of their application to review their variances. And if in this case, they've received a ZAP zoning bylaw review from buildings, and these variances are based on the review from the Toronto Buildings Department. But perhaps if this application were to be deferred, it is something in addition that the applicant can look into and verify. Otherwise, you're welcome to speak to the applicant about it or take it up with Toronto Building staff.
I would love to speak to the applicant. As I said, I've had no sort of reach out or contact with them. They haven't tried to get a hold of me. I did try to get in touch with the city from the zoning department to see what the situation was, and I haven't had a response from the examiner. I reached out to the supervisor there that mentioned that there might be some confusion, and the examiner may have overstepped as far as calling this existing when it, or in line or not. I'm just not sure what my recourse is because it is not an existing condition. It was never approved by committee. Otherwise, some of the other neighbors would have, been in opposition of the previous application. And this just seems like a process to sidestep the committee process, flat out by adding something that was never there and calling it existing. So I've just got some concerns regarding that, and no one really speaking to it.
Can I clarify that what you're saying, in effect, is that the drawings we have before us are incorrect?
That is correct. There's a previous set of plans that is also included in your package that show the south-facing second floor bump out is in plane with the brick wall, and that's the set of plans that was approved and that were tied to the decision for the committee. However, what I'm seeing in the set now is it's an existing condition with a second floor bump out that was never approved and is not part of the set of drawings. So I've been inquiring and I've been unable to get a response as to why that has happened, other than it could have been a potential error at the zoning level. I'm trying to see, well, if that's the case, then does it not need to be heard by the committee again so that they can review this variance as a holistic application and make a decision that way? But to call it existing on this set is not really accurate.
Madam Chairman, I think that we might be able to address this gentleman's concern by adding to the list of things that can happen during the deferral is to clarify the plans, because if they're wrong, it's not going to help to approve them.
Yeah, go ahead, Nicole.
Through the chair, that's correct. And secondly, to the speaker, if you believe that something was constructed illegally, your course of action is to contact 311 so the inspection process can commence. And then there is a record and it would go through the proper channel. So that, in addition, is another avenue for you.
I appreciate that feedback, and we actually have been, I've been in discussion with a few of the neighbors about that, but apparently a set of permits were issued with the bump out, even though according to zoning, it was never approved. There seems to be a tag on every one of these drawings say that bump out was approved as part of the previous committee decision, but the committee decision was tied to a set of drawings. It was never approved that way. So somewhere along the line with the zoning review, since the decision was made, an error was made, and it seems as though this proposal for a third story that is in line with a bump out of a quote existing side bump out is not really accurate, because that bump out was never approved or reviewed by the committee.
I understand your frustration. However, I just want you to understand that this committee deals with what's put before us. So we can't help you with this. I think if the deferral is granted, and hopefully the agent is listening to this, that is an opportunity to get all of this clarified, and that when they come back with accurate variances, should there potentially, you be correct, that they do need another variance for that. So a deferral is really the best way to get all this stuff sorted out. And hopefully the agent will work with the neighbors to do all of this in addition to addressing your concerns.
Okay, I really hope that's the case. If that's the event and that's what the deferral will be used for, so that the applicant will listen to those concerns and try and rectify maybe some inconsistencies on the application and request additional variances if they are needed, then I do consent to the deferral.
Okay, thank you. All right, Mr. Din, are you there?
Yeah, I'm here.
All right, you've been listening to everything that's been said, so we are going to deal with the deferral. Before we go into committee, I just want to say if the deferral is granted by committee, it is not only to consult with neighbors, but to get this sorted out, this discrepancy on the plans, and to talk to people about it. And I believe Mr. Clay has a question.
Yeah, one line, it's just confusing me a little bit. You're really just asking for an addition to the third story, yet the variances in front of us are seeking front yard landscaping relief. And I'm just wondering, why are we seeing that now? And that wasn't in your original approval, although I'm assuming it's got something to do with your front basement walkout, but you had proposed a front basement walkout in your original application that you were approved on as well. So I'm just wondering why we're seeing a landscaping variance now when there wasn't one in the previous application? Or is that just an oversight and folks are trying to correct that?
No, there's is because of the owner got a permit for underpinning the house in the basement, so we need extra step for that for the walkout to work, and there is the existing concrete porch in there, so that's we have to change the configuration of the walkout stair in order to work with the new basement level.
Okay, so you changed the design on the walkout.
Yeah, that's right.
Okay, thank you.
So the purpose of the application would need to change as well. Because it's not, to Mr. Clay's point, it's not just a third-story addition.
It does have it.
Oh, it does, it's the very end, sorry.
Okay, so Mr. Din, you will undertake to consult with the neighbors to get the plans clarified, and if you do need a variance for that bump out, you will get the additional variance before you come back should the deferral be granted, correct?
Yeah, so to clarify the bump out, the previous application approved for the FSI. So we work with the same number of the FSIs and the bump out because we make the house like shorter and we add the bump out there. So it's got a review by the zoning and building permit. So it's had the proper building permit for that.
Okay, so you can explain all of this to the neighbors when you meet with them, okay? And have a big set of, bring a big set of plans so that they can see exactly what you're talking about. All right, let's take it.
Just one last tip. The last question, you should address it back to the zoning examiner. Like, we cannot answer you that question. You have to talk to your neighbors and then talk to the zoning examiner, have a fresh zoning notice if there's something that can be reduced, and that will be very helpful for your next hearing. Okay.
Okay, Mr. Din, we're going to go into committee. Panel members to the deferral. Mr. Niffel.
Thank you, Madam Chairman. I'd like to move deferral of the application to allow the applicant to consult with neighbors and other interested parties in the neighborhood, and also to clarify the application and the variances before us.
And to repost the signs.
And repost the signs, sorry.
Okay, so that motion is moved by Mr. Niffel, seconded by Mr. Cheng. All in favor? Motion to defer carries. Okay, item number 16, 92 Hazelton Avenue. We have before us a copy of...
Chair.
Yeah.
Sorry, I just need to take a quick break. I'll be back very soon.
Okay, we can continue.
Just for myself, not...
Yeah, no
please
worries.
continue.
We have quorum. We're going to keep going, so we'll mark you absent
Understood.
for this
Thank you.
one. Okay. 92 Hazelton Avenue, item 16. We have before us a copy of the plan of survey, site plan, floor plans, and elevations. 5 photographs of the property, including trees, presentation materials from the agent. We have Forestry is asking for condition number 2. Heritage is asking for a condition that came in the supplemental agenda. Support number 97 Hazelton Avenue. No objection. Speakers, is the agent online or here? Online, okay.
Good afternoon, Madam Chair and honorable committee members. My name is Lamor Ben-Mor Mizrahi of LB Mizrahi Architects, Inc. at 321 Hidden Trail, North York, Ontario.
Okay, hi. You're aware of the forestry condition and the heritage condition?
Yes, I'm aware.
Okay, panel members, do you have any questions for the agent?
Sorry.
No?
Sorry, Chair. Feel like-
All right. Are there no questions?
No.
Okay, there are no questions. We're ready to make a decision on this. Is there anything you want to add that's not in the materials before us?
No, Madam Chair, thank you.
Okay, panel members.
I'm sorry,
Oh.
I do have one question.
Okay, there
Very
is
simple.
one question, Mr.
Apparently,
Niffel.
there's a tree removed that's, I apologize, I'm having real problems with my computer. One of the neighbors, and she didn't give her address, indicated that there's been a tree removed from the property, or there's one is being planned to be removed. Can you identify, or first of all, is that the case? And if so, her suggestion is that you replace it with another tree. Could you speak to that? And I'm sorry I didn't get that to you earlier.
Of course, through you, Madam Chair. Submission of a tree assessment and preservation plan by our arborist has been made to Urban Forestry for the removal of a white cedar. It's growing close to the north property line at the rear. It's there to allow for a grade reduction in the backyard in line with the two adjacent neighbors. As per the arborist report, this tree trunk splits into two stems at grade, and its canopy is thinning with extensive browning of tips. Two trees will be planted in its place, one in the front and one adjacent to the existing at the rear, and the remaining 3 will be paid in cash. So 3 for 1.
Terrific, thank you very much.
You're welcome.
All righty, so no questions? Okay, let's go into committee then, make a decision on this. Mr. Nipfel.
Thank you, Madam Chairman. I think this is a very reasonable proposal. I don't see any negative impacts to what is being proposed. I'd like to move approval subject to heritage condition, forestry condition number 2, and screening the north and south edges of the rear platforms.
Okay, just writing that down. Okay, are you seconding, Mr. Clay?
Yes, thank you.
Okay, so that is to approve the application with those conditions, moved by Mr. Nipfel, seconded by Mr. Clay. All in favor? That carries unanimously. Item number 17, Mr. Chang has a conflict, so he will not sitting in on this one. So it's 504 Beresford Avenue. We have before us a copy of the plan of survey, site plan, floor plans, and elevations, revised site plans, red line public notice with a revised list of variances, 4 photographs of trees, covering letter from the agent, as well as email correspondence and supporting materials. Email correspondence from transportation, they don't have any concerns. A staff report from forestry. Just give me a second here. Forestry is asking for condition number 2. And we have 30 form letters in support from residents at 462, 468, 474, 484, 492, 494, 497, 498, 501, 502, which is adjacent, 503, 506 adjacent, 508, 509, 510, 514, 516 Beresford, 599, 91, 505, 509, 513, 515, 517, and 523 Dury Street. And opposition from 502 Beresford. I'm showing one speaker in opposition. Are they online? Okay. Do we have the agent online?
I'm here, Madam Chair.
Oh, you're here, sorry.
It's okay.
Okay. If you could identify yourself, and then if you can do a presentation no more than 5 minutes. We have one opposition person.
I can do that. Hi, my name is Sandy Smith, and I am the agent, and I'm at 10 Overdale Road. The proposed project is to construct a new 2-story auxiliary building, a garden suite, in the rear yard of an existing 2-story detached dwelling. The existing 1-story detached garage will be demolished. We are seeking approval for 3 variances. Soft landscaping, zoning requires 50% of soft landscaping. With the new auxiliary building, we will provide 37.7% soft landscaping. The design objective was to increase the existing soft landscaping with the construction of the new garden suite and by demolishing the existing deck. The second variance is that no part of an auxiliary building may penetrate a 45-degree angular plane projected toward the opposite side lot line. The new auxiliary building will penetrate the 45 degrees. The design of the garden suite includes a dormer on the south side of the building facing towards the 2.2 meter wide right-of-way. The dormer, located on the second floor stair landing, allows for natural light into the suite, but due to its sill height, it prevents anyone viewing out. Dormers are allowed at the front of the garden suite. And lastly, the number of lawful parking spaces for a lawfully existing building may not be reduced. With the new garden suite, the parking space will be eliminated and not required. The owners have 2 street parking permits and have never parked their car at the rear of the lot. The clients have talked to all the neighbors and reviewed their intended proposal with them. To date, they have received 30 letters of support from their neighbors. We have 2 letters of objection from 502 Beresford, the next-door neighbor. The second letter was received by the Committee of Adjustment the day before the hearing. The client has met with the neighbor to hear their concerns regarding safety, security, privacy, and parking. While we are sympathetic to his concerns about privacy, we feel that we have not impacted his privacy. We appreciate that this proposal of a new garden suite involves some change to the existing conditions, and we feel that the changes are in fact minor in nature. The garden suite is appropriately sized, designed, and sited to respect the surrounding and the immediate context. The new garden suite will be a change for the neighbor and neighborhood. The neighbors who have submitted letters of support are very interested in the outcome of their hearing and hoping that they can build a similar project. Thank you.
Just before we go any further, are you amending variance number 1 then to read 37%, which is 5.98 meters square? Because that's the original notice went out at 20%?
At 20, and I had redlined.
Yeah, I know you did, but this is still the notice that went out, so I need you to officially do it here.
Okay.
Sorry, because I saw it.
I want to revise the landscape open space to 37.7%, which is 59.8 square meters.
Okay, so it's 37.7?
Correct.
And it equals 59.8. Yeah, I know, everybody says that, but I sent it in, and it's like, yeah, we know, but you still have to officially do it.
I understand, thank you.
Okay. All right, I'm going to go to the opposition.
Chair, can I say a point of clarification
Yeah.
before we go in? Just on your rear yard landscaping, so you've increased it, that's great. Can we just pull up the site plan, please? Maybe, yeah, blow that up a little bit. So I was just trying to figure out, so you've removed the old deck that was there. I presume that's going to be soft landscaping. You're replacing with a smaller deck? Is that
Correct, just a
what you're planning to
landing
do?
and stairs.
So all that area in between the garden suite and where your new deck will be going, is all that soft?
Yes.
So I guess my point is, you can't squeeze any more soft landscaping in there?
I cannot squeeze any more than the 37.7%.
Okay.
Carl?
Sorry, a very quick question. Can you explain to me the right-of-way that goes behind or in front of the garden suite? And I presume that's all paved as well.
Correct. It is access to parking or the houses north of our property. It gives them access to the back of their houses.
So it goes north from here.
Correct.
And it has to remain open completely. Correct. Is the right-of-way that full width, or you have a jog in there for the entrance?
The right-of-way is the full width, 4.17 something, yeah.
And is that still considered your rear yard in terms of landscaping?
It is.
So that's one of the reasons you've got problems?
Correct.
Okay, thanks.
Okay, I'm going to go to the opposition, and I'll come back to you after.
Mr. David Kondo, you have been unmuted.
Okay.
Hi, are you there, sir?
Yes. Can you hear me?
Yes, I can. Can you please state your name and your address for the record?
Okay.
And then you have 5 minutes.
Sure. Okay. My name is David Kondo of 502 Beresford Avenue.
Go ahead.
Okay, so members of the committee, my name is David Kondo of 502 Beresford Avenue, direct neighbor of 504 Beresford Avenue. As a good neighbor, my family carefully reviewed the application, and after much consideration, we came to the conclusion that our privacy would be too negatively impacted and is most affected by the construction of the garden suite. None of the issues identified and those raised by the city zoning and bylaw notice have been adequately addressed so far. Therefore, we object to the current plan, and here are the details. Angular planes. Angular planes are put in place to provide privacy to prevent overlooking into neighboring properties and I believe gardens. By varying this regulation, the garden suite will impact my privacy and do not meet the requirements. Additionally, all of the windows on the south side are facing my house, garden, and backyard. They strongly impact my privacy and enjoyment of my property and will reduce the value of the house upon completion. Therefore, please remove or relocate the windows. Soft landscaping area. The current plan is requesting that the soft landscaping area be reduced to less than the minimum requirements. Soft landscaping areas are in place to maintain privacy and manage density housing by creating space between structures. This application is another variance being requested that allows the garden suite to be built closer to my house than current zoning rules affecting privacy. The garden suite is adding to the housing population, and in this case is breaking the current zoning laws in a number of ways that will impact my privacy. By not adhering to angular plane area, soft landscaping area, it is allowing a taller structure in close proximity to my house, impacting my privacy and enjoyment of my property, which the regulations are in place to protect. Parking. Under the current bylaws, a garden suite is not required to provide a parking space, it has been argued. In this case, the impact to the neighborhood is not the fact that the garden suite is not providing a parking space, but rather the current residence is losing a parking space and made additional cars on the street. Currently, I have to park my car a few streets away during the weekend and holidays when there is no garden suite or greenways in the community at the present time. Please note that my house has only one car with street parking. I would like to ask the Transportation Department to address this parking issue. It has been argued that the garden suite is more suited to occupants who do not have cars because their suites are usually located in downtown locations with close proximity to transportation, public transportation. This is an assumption on future use of the garden suite and the type of person that may rent this property. This cannot be assured, and there is a potential that any occupant may wish to have a vehicle. In conclusion, our privacy will be too negatively impacted, and our property is the one most affected. We are being overlooked by 3 windows according to the current plan, and the garden suite is also in close proximity to our house, as it doesn't satisfy both the angular plane and soft landscaping regulations. The garden suite also introduces increased density and safety issues in the area, breaking zoning regulations in 3 critical areas that we believe impact our privacy and enjoyment of our property. We believe that these setback, angular requirements, soft landscaping, and management of parking allocation are there to protect our privacy. Per the architect's letter on the website, other neighbors are looking for this ruling as they are interested in building similar garden suites, and therefore decisions made on any variances for this garden suite may set a precedent for future constructions. However, we should do the right things in the beginning, adhering to the zoning regulations. All these identified issues should be and must be addressed properly. Otherwise, nobody would respect the rules and regulations. Thank you very much for your time.
Thank you. Any questions for the speaker? Okay, we don't have any questions for you. Thank you very much. If I could go back to you and see if you can rebut to this. We'll set the clock at 5 minutes again.
Thank you. We have heard your concerns and comments. The client had discussed the project with them individually, one-on-one, and at that time, they weren't ready to sign a letter of support, but their concerns, they didn't voice their concerns either. I just want to make a few comments regarding his concerns. Angular planes are used as a design tool to limit the impact of height in building mass, which the design has met the bylaw. Except the design does incorporate a dormer on the 2nd story, and the window is placed high to eliminate any privacy issues. There is a window on the 1st floor, but that window is not triggering any variances. The projection into the angular plane does not adversely impact the privacy on the adjacent property. The soft landscaping has been improved with the construction of the garden suite by removing the existing deck. The requirement of soft landscaping is that it supports the growth of vegetation and permits water infiltration into the ground. The soft landscaping variance does not affect the neighbor's privacy. You have noted that the new garden suite is closer to your house than under current zoning rules. The garden suite follows the current setbacks and is not sited closer to this house than what is permitted. And finally, the owner currently has 2 permitted parking spaces on the street. They have never parked in their shed on the property. Apparently, a new condo up the street has a lot of the users parking in the neighborhood in close proximity. And we asked at the committee to approve this project on the basis that it satisfies the 4 principles, which are the variances are minor, the development is appropriate, the general intent and purpose of the zoning bylaws, and the official plans are maintained. Thank you.
Okay, Mr. Clay.
Thanks, Chair. A couple of questions. So where you're proposing to build, I'm just looking at the location map and the survey. There is your neighbor at 506 has a garage there?
The neighbor to the north of us?
Yeah.
506, it's a shed.
It's a shed? But it says frame garage on the survey. Have I got the right one? Yes, I do have the right one. So I get, my point was just, it looks like your proposal is going to kind of be adjacent to that for your laneway suite, right?
Correct.
Yeah, that's fine. I'm trying to look for mitigating reasons. The other question I have is, since this weird configuration where you have a right-of-way in the rear, does that connect with the laneway?
This is the client here.
Yeah, okay, I don't care who answers.
Okay, could you speak to
It looks like it makes a connection to the laneway.
Sorry, just before you speak, I just need you to identify yourself for the record, name and address. Thanks.
Chris Beard, 504 Beresford Avenue.
Thank you.
The laneway actually ends where our right-of-way begins.
Yeah, so in effect, it's an extension to the laneway.
Yes.
Yeah, so, so you're able to park then on that?
In the right-of-way, no, because there's another 4 houses, and I would be blocking it.
Oh, so the 4 houses north of there, they also have rights of way in the rear. So why don't we call that a laneway? I'm not sure I understand why they're a right of way. But I guess maybe the other point that I'm trying to make is, even though this is a garden suite, it's kind of like a laneway suite, right? Because presumably people might have access. If they're riding a bike to their garden suite, they'd be able to access it from the laneway.
There are other rules that differentiate garden suites from laneway suites, but...
No, I understand.
Yeah.
But I'm thinking more practically speaking, how this will work.
Yeah, they would probably come down the right-of-way to access on foot, to access to the front of the garden suite.
Yeah. I'm just trying to make sure I have a visual image in my mind about what this is actually going to look like.
There is photos in one of my letters of the actual laneway that that we're talking about.
In the supporting materials?
Yes, it's right there.
Mm-hmm.
So we're on the left, and the right-of-way is in between the 2 houses, and Mr. Condo is on the right.
And the laneway goes this way?
Both directions. There's a start just south of 502, and it goes north another 5 houses.
Yes.
Great, thanks. Just trying to put it all into context.
Any other questions, Mr. Nipfel?
I have difficulty with the angular plane, and if you were here and you heard the previous application about laneway suites, you'll understand why. Had you looked at, and I appreciate why you have the dormer, it's to bring some light in. Could it not also be accommodated with some kind of a skylight, and then you wouldn't need variance number 2?
What the dormer does for me gives me the headroom height to get up the stair to the second floor.
Okay, is there,
And because I've met the requirements of the angular plane on all 3 sides, and the floor plate is quite small of the house, I had very few other ways, and I looked at it,
Yeah.
at actually getting the headroom height to get up to the second floor.
is there any way that the door, do you need, oh, I guess you do need the whole length of it, though, for the stairway, don't you?
Correct. And the window is actually located on the landing.
Oh, I appreciate that, though I don't think there's a privacy issue there, but based on what happened just prior to you, I'm concerned with precedents about angular planes, and I can appreciate why you have it here. Okay, thank you.
Are there any other questions? Okay, let's take it into committee for a decision then. Yeah, go ahead.
Yeah, I'm happy to start this one. I understand the neighbors' concerns, but I think the architect has done a pretty good job of trying to mitigate overlook and privacy concerns by sloping 3 of the 4 roof lines. And it is a kind of interesting configuration of how the lot plays in juxtaposition to others. Again, in my mind, it acts more like a laneway suite than a garden suite. And I thought the design was fine, Carl. I know I'm okay with the angular plane in part because they satisfied it on 3 sides. So I think it's a supportable application. I don't think it will have a negative impact on the neighborhood. I think it's a supportable application. So I'll move approval of this application subject to forestry condition number 2.
As amended.
Pardon me, as amended, thank you.
Are you seconding, Carl?
Secondly, I'd also like to just comment, I agree that the architect's done a really good job on this. The 2 windows that were a concern of the adjacent neighbor, as indicated, the one window that's involved in the dormer is high, and sort of chinning yourself on it, looking like this, you're not actually going to see the property next door. And the ground floor window is in a vestibule, so I don't think that they're in areas of the suite that are going to generate overlook. So I don't have any difficulty in supporting the application as proposed by Larry.
Okay, so the motion to approve the application has been moved by Mr. Clay, seconded by Mr. Nipfel, and that's as amended, with variance number 1 being changed to 37.7%, which equals 59.8 meters squared, and forestry condition number 2. All in favor? That carries unanimously.
Thank you.
Thanks. Item number 18, 417 Margaretta Street. And Aaron, are you back with us now? We have before us a copy of the plan of survey, site plan, floor plans, and elevations, 2 photographs of the subject property, a revised zoning notice, and a revised list of variances, email correspondence from transportation. They don't have any concerns. Okay, I don't show any opposition speakers. You're Manuel?
Yes.
Hi, can you just identify yourself for the record, please?
Hi, I'm Manuel Guillen. I'm from 30 Bertrand Avenue. I am the authorized agent of the homeowners at 417 Margaretta.
Okay, are there any changes to the variances that were sent out in the notice?
Yes, we would like to remove variance number 3. That is the soft landscaping requirement. There was an error from the zoning examiner. He initially thought that the lot frontage, or considered that the lot frontage was over 6 meters, but it was actually under 6, it's 5.5. And then we were also able to reduce the proposed deck on grade as per the plans. So we now meet that requirement. We don't need that variance.
Okay, so only variance number 3, you're removing, the rest stays the same?
Correct.
Okay. I don't think we need a presentation. Panel members, do you have any questions? And you're speaking on behalf of the owner, right?
That's correct.
Yeah, I do have a question.
Oh, okay, Carl and then Larry for questions, and Aaron is still not showing, so.
Could you just speak a bit about the second floor of the ancillary building and the idea that it be a deck? I have some difficulties with that, both from the point of view of privacy, the fact that it's a higher building, and so forth. So could you speak to that a little bit?
For sure. The purpose of the deck becoming accessible corresponds more to having a green roof over that platform. The reason for that is because if you noticed on the site plans, the area that's required between the space between the garage and the house, it's very limited. So there's very limited vegetation within the space as it is. In order to counteract that.
Sorry to interrupt, but what is there is soft landscaping.
Correct. So now we're proposing
But
soft
But
landscaping.
it still complies to the bylaw.
It complies to the bylaw.
Okay.
However, we still would like to, the intent of the flat roof over the garage is to still be able to have a green roof on that platform. And again, I can speak to the benefits of a green roof. They're mostly intended for community purposes. They promote biodiversity, reduce stormwater runoff. They also, have recreational purposes in terms of taking care of them and nurturing these spaces. So that is one of the areas. The deck itself is considered as such because we need access for regular maintenance to it, but it's not the intent for it to be a recreational space. It's mostly for these purposes of planting and having a green area, which is limited in this space within that area, particularly in Toronto. As for the heights, we feel that although we will be for sure asking for that variance, it's particularly talking about a privacy screen. So that might address your concern about privacy because we've spoken to the neighbors. The owners spoke with the neighbors. They let them know what their intent was, and they were happy with having those privacy screens set there specifically for that purpose. And at the same time, we believe that based on how things are evolving in planning in Toronto and how laneway houses are coming up in most of these laneways, this volume will be considered a very up to scale once laneway houses. It's just a matter of time until they start popping up. Although this is a presumption, but this is just where planning is headed. So this is just to speak to that. I'm not sure if that addresses your concerns.
But your emphasis was to provide a green roof.
Correct.
So why isn't the entire roof a green roof?
So it could be just as easily.
In which case you then wouldn't need the stairway.
You still need a stairway,
And you wouldn't need the privacy screen.
You still need a stairway and you still need a privacy screen, mostly for safety purposes because you'll still need to maintain it. So you need regular maintenance. You still need some irrigation concerns that might have, not something built as sophisticated as a commercial building. You still need to weed it out. You still might need to fertilize this every now and then. And depending on the solution, if they decide to go through an intensive which has planters or an extensive type of roof, which is mostly succulents. So that would be some of the things that we would be considering during the building permit process to make sure what's the most cost-effective approach for them.
But you'd be open to the whole roof being a green roof.
I believe that we still need the staircase for it, but yes, I believe that that's the general intent of it, considering that a green roof can be a variant of having a sedum on the ground and planters. So that is definitely something that they're up to.
Thank you.
Any other questions?
Carl had the same question I had.
Okay, is there anything you want to add before we take it into committee?
I believe that it's a fairly straightforward application, even though it's not the typical one. It meets the 4 tests because it's minor. It's more of a beneficial to the community and to the homeowner occupants, and we don't have any objections as well. So we consider that it meets the 4 tests in our humble opinion.
Chair, can I have one clarification then? So let's say that we're comfortable with this being 100% green roof.
Yeah.
And I get the point about being access. I wonder whether you need then a 1.5 meter screening. You could probably get by with what building code requires for safety purposes.
Correct.
And I think that might reduce the, the visual impact on the neighbor. So could we reduce that?
So this is mostly because not sure if you're familiar with the area. We're very close to Bloor Dufferin.
My daughter lives on that street.
So there are some safety concerns coming from the laneway, and it is their intent to tend to this roof, and make sure that it's not something that they will be. The privacy concern and the privacy screen is both to protect the neighbors from the homeowners tending this roof, and vice versa, to protect them from occupants in the laneway, temporary occupants and whatnot. So it's mostly, we would like, if possible, for you to consider keeping this height as is, but if you are willing to subject that into a condition, then we're also open.
Yeah, I'm not convinced that you need 1.5 meters. I think your concerns about privacy for the few times that people will be up there, it's not for recreation purposes, just for tending. I think the reduction in visual massing in the rear yard would benefit the neighbors more than having a 1.5 meter.
Would it be okay if they keep those along the sides, though?
Again, I think that's the issue from my perspective, is the visual look from your neighbors.
I see.
I mean, no one's complained, but I always get a little, height in rear structures, amenity structures, gets my attention. I know that other people feel the same way. I think if you reduce that, and then I'd ask the question, if you reduced it, what's code requirement for safety rails? Anybody know?
4 feet.
4 feet?
Yeah, 1.2 meters roughly.
So if you reduce that, then would you need the variance for height?
We would still need it. Our roof platform should dictate 4 meters, which I believe that's where we're at the 9-foot ceiling mark. So whatever variance we do request for height above that, that would be a variance.
So it would be then 5, well, you've got 5.2. So you're saying it's one.
We're requesting
1.2 for building code?
Right now we're requesting for 6 feet, basically.
Okay, so if you've got 4 for the meeting and you need an additional 1.2, so you've got 5.23 here.
Yeah.
You're asking for.
Correct.
So you didn't really, so that doesn't even correspond to what you were originally looking for. That's what you were looking for 1.5 meters.
So, yes, so the request is for, the bylaw allows us to have 4 meters, and with the privacy screen taking into account average grade, we're at 5.23.
Okay. So with a reduced height screen, what would you need?
I'd have to do the calculations graphically. I would say...
really want to jump in because I don't think this screen is necessary. If you are doing it as a whole full green roof, which means this green roof is considered as something not occupiable.
Aaron,
Right.
the applicant
kind of green-
indicated part of it was to screen view of the people tending the green roof and also to screen them from the people on the laneway, but I'm on the same side as you. I'm not buying this.
Aaron, is there a requirement for like a safety rail at all? Like that would be really.
That's what I'm trying to say. If the green roof is not, because the reason why he needs a roof now is because there's an occupiable space, which is an accessible roof deck, right? And you do need a guard.
That's the only I'm concerned with.
But if this is all green roof, you don't need any of this guard at all.
So,
because this roof is no longer
So-
a occupiable space.
if I may add, members of the committee, so this is not a commercial green roof per se. So it's going to be tended by homeowners, which include children, right? So we would definitely like to maintain some sort of safety. And green roofs are not self-maintainable, even though that's what the appearance of the commercial roofs is. They do need to be tended, and it is an opportunity for creating, memorable moments for this family to be able to tend to this. Now, the definition of green roof as well is subject to interpretation because, like I mentioned, you can have different types of green roofs. So you can have planters, or you can actually have sedum. So there's different types of green roofs that you can actually look into. Now, having safety guards, privacy screens, obviously that would be a nice to have, and we would like to see if that could get approved. But I believe that railings and safety railings should be a must, particularly because we are expecting a family to be tending to this. Getting closer to the edges, even though it's only a one-floor platform, would be considered a hazard safety. And we are creating an access to this roof by way of a staircase. So what that means is that we definitely need some sort of safety guard around it.
That's exactly the reason why I want you to remove it, because we are talking about allowing you to have zero soft landscape, right?
No.
I'm just considering. At the back-
Sorry, Aaron, that variance was removed, variance number 3. Was deleted.
Sorry, say that again. Delete it. So you will have that, and you will have the roof. So you still want to use the roof as a leisure space?
Yes.
And a green roof?
Yes. The distance.
So 100% green roof?
So the distance between the garage edge and the house edge, as is very limited to what they can actually grow in there. Grass has a hard time growing there.
Right.
Sod and other vegetables, for sure. Highly likely that the homeowners would like to have some sort of a planter at one point tending to it up there. So it's definitely something that could be a benefit for the community as well, right? So it's really our idea to make sure that whoever has access to this platform will be safe.
Yeah, because what your original design was shown on the screen now makes the most sense. But then, if we ask you to put it with a full green roof, that will become a very interesting situation. I mean, we would still like you to have full green roof with the railing. I don't know how you can sustain the green roof of all these screens.
What about a screen with some kind of planting? Would that be an option?
For sure. Any sort of screen would be okay with us, as long as it can provide.
I mean, that would be visually nicer for the neighbors if it was some kind of a climbing vine. Carl?
Alternatively, I'm sorry, we're playing.
No, for sure.
Of options. Would it be reasonable? The issue is you want the people up there so that the children can experience
teachable moments, correct?
Which is good. Once they're up there, you have to be careful that they don't fall off. Is it possible that you could provide a continuous planter around the edge of that level?
It is possible.
Plant it and use that instead of this screen that you're proposing?
Yeah, that would be very possible to have that with vegetation. I don't see why that would be an issue.
I think that's a better solution to the concern that Mr. Clay raised.
Sure, yeah. Yeah, we would have to look into vegetation landscaping that would allow for that privacy, and then they would be open to that.
Okay.
Well, we would want to put a condition to that effect in.
Sure.
Okay. Are there any other questions?
Through the chair, the purpose of the application also refers to this as a rooftop deck. Would that need to be amended to green roof?
Yes.
Okay.
Now, I just want to clarify. The condition now becomes, we are asking the applicant to have a full green roof, planters along the perimeters of the full deck. Is that the condition?
That's
Well,
what we're talking about.
We're not there yet, but that would be the condition, but
I know, I'm just, right, yes. I'm just curious how, because we might have to come back to the applicant and see,
But Mike, like, to you, Madam Deputy Secretary Treasurer, if we change the purpose, right, they want to use it as a deck. they're making it green, so should it not stay like the words rooftop deck in there? Like could be green rooftop deck, because it's not just going to be a green roof.
Except I think the difference, and it's a big difference, a deck assumes people are out there sunbathing and having cocktails, and that's not the objective here. The objective here is to use the green roof as a learning laboratory for children.
But they're still going to be up there walking around using the
Yeah, but there's a
using the
difference
space.
between that and recreating, right? I
Yeah.
think we've used this in the past where we put a condition in that it not be used for recreational purposes. And that seems to satisfy the concern about putting chairs up there and that sort of thing. It is a green roof. I think the applicant indicated that they're going to make it a 100% green roof.
Through the chair, it would also depend on the condition. If the committee was imposing a condition that it be solely a green roof, then the purpose would have to be amended as such. However, if it's staying flexible, if there's not a condition to say it solely shall be a green roof, then it could remain as a rooftop deck, and then you could just impose conditions about planters. So it really depends on which, if any, conditions you are imposing for the purpose.
Okay, well, I think we need to move forward with this.
Yeah.
So, okay, let's take it into committee then, and I'm in your hands with respect.
Well, just a comment. I'm okay with the proposal that it be a green roof. I'm less okay with a provision that allows it for recreational use. I don't think that is our intent in terms of the approval. So I would prefer, from my perspective, to have it a green roof with the planters around the outside. And that, I think, speaks to the elimination of it as a use for recreational purpose, because I think we've seen those kinds of applications come before us in the past, and those kinds of applications generate conflict. And I'm not sure that's what the bylaw is intending to do.
And I wonder if, taking the applicant at his word, if we would avoid using recreational use, because I would argue that what the gentleman's talking about is recreation. So I'd be inclined to say that the roof is to be used as exclusively as a green roof with access only for maintenance.
Yeah.
And that, I think, is really clear. That's what we've all been talking about. And that the edge of the green roof is to be provided with planters and planting materials to provide for safety. That seemed to me what we were talking about.
Okay, so are those like the conditions then that you're putting forward?
Could I ask a question, if I may?
Well, we're in committee, but we'll come out of committee. Go ahead.
So I could still have a railing outside those planters for safety purposes, just because by code, planters are not considered as guards. So would I still be able to actually have a 4-foot railing behind those planters and then have planters which...
So you're saying you need to, by code, have a guard there regardless?
Well, if there's an access to it,
Yeah.
yes.
Okay.
This is why, sorry to jump in again, this is why I think what the committee wanted is a little bit contradicting to what you really want, because we're trying to make it as a green roof and just for maintenance purpose only, not for recreational use. Whereas once you put the railing or guard, automatically it becomes a deck for leisure use. See, that's what I'm trying to help you to achieve what you're trying to do. And we also have to worry about granting these variances. For example, let's say you sell the house next year to a new owner. How can we ensure that it is not just for children use, right? So that's the balance we have to find here. And you're right, you might not get the building permit if we ask you to with the condition that we're putting on now, because it's not for leisure use, it's for maintenance only, and this is why the guards are not necessary.
So
very unique situation.
So Aaron, are you saying that?
He's agreeing with us.
Yeah, no, but if we accept the applicant's request to put some sort of railing, safety railing up there, you think that that changes the use?
Yes, because under the building code, once you're railing on the platform above certain height, I can't remember the number, then it automatically is a deck, which is exactly how the description of the purpose of the application. So I have a proposal, maybe we can discuss further, which is basically allow him to install the railing, but the railing has to be transparent, or it just can't be full block like how it's showing on the rendering, and with the plants around, so that can achieve the look that we want to have, right? And then if we ask for a 100% green roof, then, you know, I mean, the new owner can remove it and do whatever they want, but that's something we can't control. But if we trust him, but this is the way how it's going to be, then that's the only way to go.
So you're suggesting the purpose stays the same, we do the railings as per code and make them of material acceptable to the committee, is that what you're suggesting?
Yes, correct. That would be.
But you're also saying we have a condition that it's 100% green?
Yes.
Yeah, okay, good. I'm fine with that.
Okay, Aaron, we'll go back into committee, why don't you make the motion?
Okay, so I'll make a motion to support this application per amended, and with a condition of having transparent materials for the railings or guards at the platform. And then I guess another sentence will be the roof of this platform has to be 100% green roof with planters around the perimeter.
And also access only for maintenance.
And access for maintenance only.
Okay, I agree with that, but I do think that suggests a change to the purpose.
Yes.
No, I thought Aaron said that the purpose would remain the same. Okay, well.
Remain the same because he said the children wants to play up there.
We're in trouble.
Through the chair, the purpose should reflect, if you're imposing a condition stating that it should exclusively be green roof, then the purpose should reflect that. And so regardless of building code, I mean, if you're imposing this condition, then I think that's okay. I think that would be sufficient.
Okay, all right, so all those conditions then, as outlined by Mr. Chang, and the purpose is going to read that it's a green roof? Okay, so that's moved by Mr. Chang, seconded by Mr. Nipfel. All in favor? That carries unanimously.
Phew.
Thanks. Okay, item number 19. 68 Rathnally Avenue. We have before us a copy of the minutes from the April 26th meeting, copy of the plan of survey, revised site plan. Do I have the agent on the line? We have one variance before us.
Hello.
Hi. Can you identify? Hi. Can you identify yourself for the record, please?
Yes, my name is Tarunpreet Kaur, and my address is Unit 5, 600 Zenway Boulevard, 1.
Hi, and you're speaking on behalf of the owner?
Well, owner is here to speak.
Okay.
So I would like if you can give him a chance first to speak.
Well, I don't think we need a presentation, but if the owner wants to say something, although let me see if there are any questions first.
Hi, my name is Edward Troon. I'm the owner of 68 Rathnally Avenue.
Okay, hi. We don't need a full-blown presentation. There's one variance before us. I know that you've increased from when you were here before. I believe it was 5.7%. It's now 11.54. Is that the best you can do?
Yeah, there's because of the setbacks related to the pool and a large chunk of my backyard is really occupied by the driveway and the garage. I've tried everything, but that's the maximum that I can come up with.
Okay. Anybody have any questions for the agent or the owner?
Can we just put up the site plan? The next one. Yeah, that one.
There's a revised site plan.
Is that the revised?
Yeah,
of the- Oh, pardon me. Revised site plan. So where have you increased the soft landscaping? Oh,
So I think
next to the
originally
pool?
Correct.
So what is all
And
this? What's the treatment of all the rest of your backyard?
Oh, it's one of the issues that I have is that during the winter, I have a very long and narrow driveway, and I have right of way over my neighbor's yard. And so what I need to do is I have to push the snow all the way to the front of the house. It's about 120 feet. And with the pool, I can't put it on top of the pool cover. And so all of the material is basically concrete with heating underneath.
And the pool is existing. So what about that area between the pool and the pool equipment room along the property line?
So there's it's not shown, there's a barbecue area there that abuts the garage, and that is also all the same material, heated to get access to the equipment room.
Sorry, it's heated under, so all that concrete is heated?
Heated, yeah.
Yes.
Wow. Where does all the water drain to when you heat the snow?
Yeah, that was one of the things I'd like to articulate. So when they originally designed the pool, there is a channel that runs about 2/3 from the garage all along the about 4 feet from the pool area. And then on the end, on the sort of the south side, there's another channel that runs the entire length from the garage straight to the almost to the house. And when they originally designed that, I said, listen, I don't want to have any issues with respect to drainage. I'd like to over-engineer that. So they made the drainage channels 50% more than they would otherwise have done. And then I further asked them to add a sump, and the sump is located on the south east side of the garage.
And where does the sump discharge?
Into the ground. It's about a 6 foot deep hole.
Okay.
Mr. Nipfel?
So the entire rear yard of this property, with the exception of that little slit that's beside the pool, is all concrete?
Yeah, concrete or stone.
And heated.
And the entire area is heated?
The area with the diagonal hash marks, that's stone, that is not heated.
But the rest of it's all heated?
Yes.
No.
So I just want to bring up a point. The existing pool is considered a soft landscape in the calculation. So I think that's how they got 5%, right? And then the additional landscape, the actual landscape that we're looking for is the one on the revised plan next to the pool.
Yeah.
And you're proposing to have a deck to cover that.
No, there's no deck. The deck's already there.
Sorry, proposed patio cover. Right, I see.
So the other question I have is, you're here because you want to put a canopy over a deck. And
that's right.
There's a variance here for soft landscaping. Is none of what you're proposing to do with the canopy over the deck is generating this variance? That's an existing condition, is that correct?
That's correct.
So before you made the revision, you had 5% of the rear yard in landscaping, and now you're proposing to do 11%.
Yeah, it's actually, it was, what was submitted prior was an error. So it didn't include the spa area, which is also part of the pool. And then the actual softscaping, I don't know why that was missed, but that was just an error. So this is correcting the error.
So is the 11.54 correct?
That's right.
And I know I'm restating this, but all that area in the back, which is concrete, which has the little triangles in it, all that is heated.
Yes.
Wow.
That's correct.
Wow.
Yeah, it's, I mean, the snow removal has been always a real problem for me. And this was the sort of the best solution. Unfortunately, it's a little expensive to maintain, but it was the best solution to deal with the snow.
You could have had soft landscaping for some of that though, and the snow would melt and go down into the ground.
I guess perhaps, yeah, in the back of the pool area, that's possible.
Okay, any other questions? Okay, let's take it into committee then.
Yeah, it's a very interesting position because I think you would be, anyone could pour concrete and heat the backyard if they don't build anything, right? There's no building permit required for that. So he did that, and then now that you want to put up a canopy, then this heated backyard is now discovered and become an issue.
Well, the softscape requirement is always there. It's just that, you know, the city doesn't catch it until, as you say, something comes before committee or you apply for something else or a neighbor sees it. Carl, you wanted to weigh in?
Thank you, madam. Are we in committee yet?
Yeah, we are.
I do not support this application. I don't think that this is a reasonable percentage of landscaping, given the overall picture of the city and the need to generate some kind of control mechanism over increasing climate issues. So I'm not able to support the application. I'd like to move that it be refused.
Okay, do I have a seconder?
I just want to ask, can we
Okay, so that does
Go back.
not, that doesn't carry. So, yeah, go ahead, Aaron.
Can we go back and ask the
You want to come out
the
of committee?
applicant is-
Yeah, we're out of committee.
yes,
Go ahead.
just to ask, give him one more chance to see if he can improve the landscape percentage. Hi, Mr. Applicant.
Mr.
Hi, hello.
Truitt or the agent?
Agent, yeah, sorry. Are you able to convince us with some solution that you can help us to increase the landscape, soft landscape at the back? Because I don't think you need such a, I know you have to deal with the snow, but, and you need to drive your car through the right of way to your garage, but for all the remaining space, are you interested in improving the landscape?
I guess the only solution would be to actually rip out concrete, and unfortunately, underlying that concrete is an entire heating system. I mean, I could add plants and that type of thing, like a long planter, to add softscaping that way, if that's acceptable.
Where would you put the planter or planters?
I think I would put it sort of adjacent to the garage along the fence line.
Okay.
And that's probably, I'm going to guess, a 8 to 10 foot length. And I could probably do that a foot, maybe 18 inches wide.
Okay. Is there anything else you want to add before we go back into committee?
No, I've looked at every sort of square inch. I mean, what is not included in the softscaping are the actual drainage trenches. I couldn't quite get clarity whether they should or shouldn't have been. but those aren't in the numbers, yet they're in existence, so I'm not sure if that's a positive as well. And that's about it.
Is your garage peaked or is it flat?
It's peaked.
Okay, let's come back into committee then. All right.
I find myself a little on the fence on this one. I mean, the fact that it's already constructed and it's poured and there's, heating elements underneath, ripping that up seems, in my mind, a little excessive. I mean, quite frankly, it's a bad decision to concrete your entire backyard and heat it. I understand, the convenience of that, but I'm surprised that didn't get caught when it was being done. Having said that, the soft landscape has been increased. There is maybe an opportunity to put some planters in. I don't know. Aaron, what do you think? We know how Carl thinks.
I actually have a question to the staff. Is what are we trying to legalizing? I mean, maybe that's not the right word, but if somebody changed the backyard to such a condition that doesn't meet the bylaw without approval, does he need approval to do that? Because are we doing?
Yeah, I think in essence, the paving of the rear yard was done in violation of the bylaw, right?
Right. So we are also legalizing the act of this backyard
And
by approving.
creating an environmental issue that is inappropriate.
Through the chair, there's no order to comply listed in the system. There's been no violation levied against this property. If you want to amend the purpose of the application, you could perhaps add to permit or to maintain some existing condition, but we can't say legalize when there actually hasn't been a violation issued.
Somebody have to report him to come up with comply. So I have no issue with the cover. It's just the backyard situation and the way how the variance tied to this application is getting very uncomfortable.
Yeah. So the more I think about it, it just seems to me that there's an opportunity here to do better.
Absolutely.
I doubt very much whether the applicant would be able to achieve 50, but going from 5 to 11 doesn't seem to me to be an ambitious effort. So I think, maybe there's an opportunity to do better here. I mean, I take his point about the heating underneath the pavement, but there might be a way to achieve some soft landscaping with a similar approach. So the more I think about it and we talk about it, the less comfortable I am with approving an 11%, which is almost a 40% deficit in landscaping. And I think that's excessive, and we've turned down applications that are better than that.
Yeah, and in fact, the canopy, the construction of the canopy or the cover is going to strengthen this condition. Because having a canopy, that means there's no future, it'll be even more difficult to put more landscape in the future.
Yeah, the water will spill out onto the concrete rather than go through the deck. Yeah.
Right.
Okay, then, Carl, do you want to do the honors?
I already did.
It was struck, okay, so Madam
There's a motion to
Deputy
refuse
Secretary Treasurer, the motion was struck down before.
Okay, let me move again that we.
Can we move
refuse
the
app-
same motion again?
Through the chair, to be on the safe side, perhaps we can have a new motion from
Oh, sure.
another member.
I'll move a refusal of this application.
Okay, so Mr. Clay moves refusal of the application, seconded by Mr. Nipfel. All in favor? That carries unanimously. And to the applicant, yeah, I was like Mr. Clay, somewhat sympathetic with the heating especially, but perhaps you can go back to the drawing board and figure out a way to come back with more landscaping. The final item this morning is number 20, 154 High Park Avenue. We have before us a copy of the minutes from the July 19th hearing, copy of the plan of survey, site plan, floor plans, and elevations, tree preservation plan prepared by Coons Forestry, covering letter from the agent, arborist report from Coons Forestry. We have a staff report from Forestry. They're asking for conditions 1 and 2. 9 form letters in support from 136, 140, 141, 149, 151, 153, 155, and 270 High Park. And opposition from 213 Quebec Avenue. I do not show any opposition speakers. Do we have the agent on the line?
Yes, good afternoon, Chair and members of the committee.
Hi, and I just need your name, please.
Yes, Marco Razzolini.
Okay, don't think we need a presentation. Panel members, any questions for Mr. Razzolini? Anybody?
Nope.
All right, we have 2 variances, sir, ready to make a decision on this. Anything you want to add that's not in the materials?
I think most of it is covered in the report. Happy to answer any questions if any come up.
No questions, so we're going to take it into committee for a decision. Mr. Clay?
Sure, I'll happy to do this one. This is 2 very minor variances before us. These are a neighborhood, and this street is characterized by very deep lots. And I note that the lot fabric is such that even extending out into the back, 154 probably would be, rear would be in line with all the other structures and dwellings on that street. So I don't think it would be out of character at all. I think the lot and the street can handle the additional density. I'd like to move approval of this application, subject to forestry condition 1 and 2.
Consider a friendly amendment that the balcony is to be screened as shown on the drawings. It's shown on the elevation drawings and it's shown on the...
Oh, do you want to tie the elevations?
Yeah.
And tie the approval to the elevations for the purposes of ensuring the screening of the deck.
Okay, so motion to approve the application with the conditions outlined by Mr. Clay, moved by Mr. Clay, seconded by Mr. Nipfel. All in favor? That carries unanimously. Okay, the committee stands adjourned at 2:06 p.m. Thanks, everybody.
I thought it was...
Thank you all.
I thought it was 7:35.
Bye-bye.
Bye, Aaron.